Mr. Anthony Williams was on that same phone plan that Ms. King was paying for, that the defendant was using. And so in terms of any evidence that anyone else was using that phone, Your Honor, there's been proffers of things that were supposedly be said by the defense. However, there is no evidence before Your Honor that anyone else other than the defendant used that phone. And I'd be happy to put together over lunch a compilation of every single one of the screenshots that the defendant took on almost every FaceTime call that includes him in this small box, which would be indicative of who is using that phone, and the other individuals that he is calling as the larger picture.
Your Honor, some of the evidence is before you now, which is Mr. Williams, who was also on that plan, was also using that phone. His nickname was Sack Chaser. Right before you, you will notice that all of those messages are coming from Sack Chaser. I'm not claiming that that means that all of those messages are from him. I am saying it's proof is positive that the phone was being used by him at times, or that would never have materialized in that way. And this notion that you go to a pawnbroker, yes, maybe the day that Mr. Demons was at the pawnbroker, he gave that phone number because he knew it was one he could reach. Just like last night when I went to go buy face cream for my wife, they asked, do you have a number with us? And I gave them her number because that's the number that is associated with our Walgreens account to get credits. And when I go to Total Wine and they ask me, I give my number. And that's how that works. And so the fact that he may have identified that as a phone that he could be contacted at when he did a certain pawn transaction is not dispositive proof that he's the exclusive user of that phone. The fact that Sack Chaser's name is associated with that phone is dispositive proof that he was using that phone. And the fact that the phone was being used after Mr. Demons was incarcerated is also dispositive proof that the phone was being used by others. And the way that we can solve this is that the state can lay the foundation for each conversation they want to get in. And if they can't, it means they don't have the proof that it is him. If they can, then they do have the proof and it should be admitted. But that's all we have.
Thank you. And the phone itself, when was the extraction done?
The extraction was done February of 2019. I believe February 23rd or 28th. I don't remember exactly. It's on the analysis. The report that is generated, which is what's put in evidence, is generated in June of 2019. This was the phone that the defendant's manager brought to the state attorney's office and was identified during that conversation by the defendant's manager as being the defendant's phone that he was given after the defendant went into custody. There are multiple messages and things that I'm happy to show the court that, because that item is in evidence, and I can put together a composite over lunch to show exactly the number of times the defendant is pictured on that phone, including the various accounts that have already been introduced, such as the Snapchat account, the email accounts, of which we have the Apple records and the certification on that for those phones, that it comes back to YNW Melly booking at gmail.com. And that email address, in the terms of when that was created, all of that is also subject to the search warrant, specifically which this witness looked at, which we can talk about the creation date of the account, which predates any of the activities in this case and all of the names that are associated with it of Jamel Demons.
But you're telling me the phone was turned over to the state attorney's office or the police on or about the date when Mr. Demons was arrested?
No, Mr. Demons turned himself in on February 13th of 2019. About 2 weeks later, his manager came to the state attorney's office to give a sworn statement and brought the phone with him.
That's
Passcode,
Mr. Francois?
Mr. Francois. The passcode to access that phone was given by this defendant in a jail call that I have, like I mentioned previously, to his mother, where he's telling her how to and what code is associated with the phone. That is how the state attorney's office, with the help of law enforcement, was able to get the full extraction that we have, because this defendant, on a recorded jail call, gave the passcode to his mother.
A couple of things, Your Honor, in retort. One is if YNW Melly is like any other artist, the person who does their bookings is their manager, the person who had phone in hand. So if it's coming back to YNW Melly booking, that would suggest that it's the manager who has possession of that phone. The other thing that suggests he had possession of the phone is he had possession of the phone and he turned it over. Now, the fact that Mr. Demmons knows the passcode is, again, not proof dispositive. That phone was being used by others while he was incarcerated. So other people clearly knew the password to the phone, or they could not have used it. And third, I'm not sure that Mr. Francois coming in here and saying it's Mr. Demmons' phone would be sufficient. I don't know that that would not be some form of hearsay, but at least that might start to approach some sort of foundation. All the foundation that's required by law to be adduced and elicited and put into the record is coming from the state attorney's mouth at that desk, and it's not in evidence. So all the things that she's saying establishes it as his phone are the very things that the case law and rules require be adduced before that jury. And so the fact that she understands that is evident from the fact that she is presenting it as the foundation for why she's trying to introduce this information. But this is not the forum to do it outside the presence of the jury. Do it in front of the jury if you have the witnesses, because otherwise it's hearsay. Her saying that Joe Blow told her that somebody else owns a phone is not legal foundation sufficient to satisfy the rules of evidence.
All right, so counsel, I'd like to see what you have and show me, we'll talk about how you, what evidence you're going to have introduced to authenticate it and how to commit. All right? So we'll see everybody back at, let's see, 1:15. All right, thank you.
Thank you, sir.
Cell phone evidence, and I've just been told that they've actually wrapped up. So we will go ahead and get to your questions. YNW Melly, of course, is the South Florida rapper accused of murdering two of his friends, Anthony Williams and Chris Thomas Jr. They went by YNW Sack Chaser and YNW Juvie. We've been covering this case for a little more than a week now, and it's a pretty interesting one. YNW Melly, whose legal name is Jamel Demmons, says that he did not commit these homicides, but the state says otherwise. So keep your questions coming to us on Twitter, YouTube, Facebook, Instagram, and TikTok, and we will get to as many of them as we can. For now, though, I want to start with Terry Austin, who is in the courtroom, in the courthouse there in Broward County, Florida, to bring us up to speed on what it's been like in court so far this morning. So, Terry, what's the mood like in there today? And did you notice any anxiety with this juror as the detective was testifying?
Well, there was a lot of anxiety in that courtroom. There was a voir dire of the witness. He was, wearing a mask, and they wanted to talk to him about why he had that mask on before the jury came in. He testified that he had the mask because there was a bounty on his head for $50,000 and he was in fear of his life. For those reasons, Judge Murphy said, okay, you can wear your mask. Now we have a juror who has some concern about the witness wearing the mask. There were a couple of questions. One was, I'm very uncomfortable. The other issue was, why is he wearing a mask? We're not wearing masks. So they are trying to determine what to do with that issue. The judge said, we'll take that lunch break. We'll determine over the lunch break what we're going to do. There were a couple of options that were proposed. One option is to clear the courtroom and have the witness take that mask off so he would not be intimidating any of the jurors with the mask on. And another proposal was simply have a jury instruction that is more detailed. The first jury instruction that the judge gave basically was, look, this witness will be wearing a mask and you are not to infer anything with that. This second jury instruction, if that's the way the judge decides to go, will be much more detailed. So he's thinking about that over the lunch break, and we'll have some sort of resolution when the break concludes.
I want to bring Brian Buckmeyer into this conversation really quickly. Brian, you were a public defender doing homicide cases. This is pretty unique. We are getting a really good look into the gang life, the concerns that come with policing and working on gang cases and stuff like that. So I have seen personally officers wearing these types of masks when they're out executing warrants, doing things like that when it's related to big drug cases and gangs and things like that. I've not seen it in the courtroom, but I understand the concern of this guy. He says he's got a bounty on his head, but also we do have that confrontation clause issue where the defendant has a right to confront his accuser. And also it does impact possibly how the jurors are able to evaluate this person's credibility.
Yeah, so let me pull a lot of that apart. First of all, the confrontation clause doesn't say you have the right to confront your accuser. You have the right to confront the witnesses against you. And the way that the constitutional law looks at that is you're allowed to be in court with them, you're allowed to have them present, you're allowed to cross-examine them. It's not like what we've had sovereign citizens in the past saying, well, the state is accusing me, so why isn't the state coming in? It's not really accuser, it's more witnesses. Also, it's not literal in the sense that you have to see their face. While this is rare to hide someone's face during testimony, and especially during the pandemic, many defense attorneys, including myself, made the argument that we cannot test the credibility of this witness if they're wearing a mask on their face, because that's the way that people perceive truthfulness, honesty, dishonesty, whatever it may be. It's a balancing act. And I mean no disrespect to this witness, but the life of a person and potentially the life of their loved ones, whether it be husband, wife, children, parents, whomever it may be, because we know that gangs don't just go after one person, they could potentially go after a family. That risk, at least in my mind, far outweighs any discomfort you may have from seeing someone testify with a mask. I think the witness explained it very well. I think everyone is a reasonable person in that room. Also, most of us have lived through the last 3 years of seeing people with masks. I don't think this witness testifying with a mask should be that big of an issue. Give a curative instruction or some kind of instruction come time for deliberation. But I side on the side of safety for this person's life over another person's discomfort.
Yeah, most certainly. I mean, I don't think any of us can imagine what having a bounty on our heads is like. This guy, people want to kill him, and people will be paid to kill him. So a lot of us are not able to actually put ourselves in that position. So it'll be interesting to see what happens. The concern really is what's going on with this juror as well. Is this going to impact her ability to be fair and impartial? Let's get to some of your questions. Offie Patterson is with us as well out in California. Our first question, I'll throw this one to you, Offie. It's from EJ2882 from YouTube. Will they have enough evidence and prove him guilty? Me, I think no. So, we got to be careful with that because the case is not yet over. But Offie, what are your thoughts so far on how the case is going?
First of all, thank you, EJ, for your question. If I can tackle really, really quickly what you guys just addressed with respect to the witness, I would like to say, find me an expert witness that can testify without a mask. I think it's highly prejudicial and inflammatory, and that would be my first objection as a defense attorney, because as a juror, I would start thinking, what in the world have I gotten myself into? What is the defendant involved in? Is anybody going to come after my family? Now, with respect to EJ's question, has there been enough evidence or is there enough evidence to convict Melly? Maybe there is. I don't think that enough has been presented yet. I think the prosecution is definitely, circling with the helicopter and they haven't landed yet, but it looks like they are trying to land and they're just trying to piecemeal a lot of the evidence that they can put together as best they can to bring about a conviction.
Well, let's keep in mind, though, this officer, this detective, he's on the stand testifying about wiretaps and stuff like that. So, he has involvement in the case. So we need to keep that in mind as well. And there is a gang aspect of this case. So it'll be interesting to see how this all unfolds after lunch. The judge may do what Brian just suggested as curative instruction. All right, Kirsty Walden from YouTube. What does this have to do with the case? Asking about undercover detective Danny Polo. So Terry, what does this have to do with the case? Clear that up for Kirsty, if you don't mind.
Okay, so good question. The prosecution is bringing on undercover agent Danny Polo because they have alleged that Melly is involved with a gang. And so they are trying to make that connection with the gang, the Bloods basically. And so this witness is testifying about his undercover operations, what happens generally. And right now, we've only heard about general undercover operations. We have not heard anything specific about this operation. So I think what the prosecution is going to try to do is to say, what did you do in connection with this case? What did you do in connection with Melly? What did you do in connection with any sort of wiretapping? And if in fact they learned any information, this would be the witness to get that in. They've alleged that he's involved in the gang. They've stated as an aggravating factor that he's involved with the gang activity. And so that's why they're bringing this witness on the stand at this point in time.
Sure, go ahead, Brian.
Yeah, so gang life, like any other type of close-knit communities, is a subculture that many people aren't open to. You don't see it. I'm not going to throw up gang signs, but handshakes, hand movements, verbiage, different types of way that people articulate themselves in a gang or in that environment is very different than what people may know in their everyday life. It's like lawyers and non-lawyers. We have our own language that you may not know about. So you put on a witness like this to educate the jury to say, hey, what you saw there in that video isn't just a handshake. That's something gang related. What you saw here or what we're trying to present here isn't just some kind of awkward happenstance. It's gang related. And so they're trying to associate what might go over some people's head because they're not knowledgeable in gang life and try to educate them. Even the tattoos on YNW Melly's face and his body, that can be an educational way for the jury to learn about why there's a gang connection based on the prosecution's perception.
And let's keep in mind, just so the viewers are aware, and we thank everybody again for joining us and keep the questions coming to us on social. You're right, Brian. A lot of people, regular people watching this unfold, average everyday people are not familiar with gang stuff. And Christine Bradley talked about this in her opening statement. She said that they were going to see things called stacking. And this is a way to show that you're in a gang and making symbols and stuff like that. So she discussed this and said this was coming up. We're going to take a quick commercial break. So we hope you stay with us. As I mentioned, keep those questions coming on YouTube, Twitter, Facebook, Instagram, and TikTok. We'll be right back. I'm Anjanette Levy, and you're watching Law and Crime. well as Offie Patterson. She is a lawyer out in California. She is with us this hour. Offie, I'll send this question over to you. It comes from Turtle0086 from YouTube. This case sure has had it all. Hostile witness, motion for mistrial, discovery violation, defense/prosecutor bickering over printouts, jurors being replaced, countless sidebars. What's next? I mean, it kind of makes you wonder, Offie, what could happen next here?
Anything could happen next. Thanks for the question, Turtle. I think that I have been fascinated by this case, just looking at defense counsel. I've always said he is giving us a masterclass on evidence and courtroom procedure. He is showing us the importance of thinking ahead and foreseeability and preparation. I absolutely love how he pulls out primary authority. I love how he does his research, and he's ready for everything that the prosecution has. And I think that it's been fantastic for me. I think it's weighed a lot on the jury. And I think that especially for the prosecution, they don't appear to be prepared, cooperative, or forthcoming. And I think that may have an adverse effect on their case in chief, but we'll see. Again, Turtle, anything could happen next.
Anything could happen. This is turning out to be one of those cases where you really tune in because you don't know what could possibly happen next. And I agree with you, Offie. I think David Howard is very good attorney, really on his toes. Brian, let's send this question over to you. Bree Wetz from Facebook asks, why drive to the hospital and not call 911? I think that's a very good question. And Cortland Henry Bortland is the only one who can answer this.
Yeah, it's a good question. I don't know if it's ever going to be an answer for it, at least in this case. Maybe Cortland Henry takes a stand and testifies. I would assume if you have two people in the back of your car bleeding out, driving to the police is going to only amount to questions and not getting medical aid or life-saving aid. While driving to the hospital, you would get aid and then questions. So I think it's the emergency of the situation. People are dying, you go to a hospital, you don't necessarily go to a police precinct.
Well, and to be fair, none of us know how we would react in such a situation. But the prosecution would tell you he did this because they were staging this whole thing, he and Melly. The defense, we don't know what they say about that part of it. Roddy Dreco from Facebook, Terry Austin asks, why does the prosecutor think Melly was the only shooter when YNW Bortland was also inside the car?
Well, I think the reason the prosecution is focusing on YNW Melly is because he was sitting in the back seat. And according to their forensic experts, the bullets that were the kill shots came from the back seat. So Anthony Williams was in the front passenger. The bullet that killed him came from the back. And Christopher Thomas was in the back seat, and they're saying it came from the side. Now, of course, their bodies were riddled with bullets because it was, according to the defense, a drive-by shooting, and there were lots of bullets in the bodies, in the car. And so the kill shots, and that's exactly why I say I want to hear what the medical examiner has to say. They are going to testify according to the prosecution. What she said in her opening was that you're going to see that these bullets came from inside the car. And they're not saying that Henry was the one who shot that gun because of the angle of the bullets. They're saying that he was the driver. And if you remember, they are charging Melly with not only, 2 counts of first-degree murder, but they are asking for the death penalty. They are not asking for the death penalty in connection with Henry because he is not the shooter, or at least I'm assuming that that is the rationale why they're asking for the 2 different punishments.
Yeah, I think you're right on that one. Also interesting to point out that the medical examiner, according to Christine Bradley, is going to testify that those shots fired from outside the car hit the victims when they were already dead. So I think that will be very interesting testimony to hear once we get to that point. Another question now, Brian, I'll send this one over to you. It's from Dior_me_me. Who we had on yesterday as well, asks, what is allegedly the key evidence connecting him to these?
I just want to say this, and I ain't going to stop it no more. But one of the biggest mistakes or key evidence they had was that telephone, Melly phone. And if the people that just came in and didn't see it, Melly phone, his phone was in Sack Chaser name. And Sack Chaser also used Melly phone sometimes too. So that may be a big break for Melly, that his phone was in Sack Chaser name.
To these murders for a conviction. I'm only hearing strong possibilities, like a flipped coin.
Well, Dior, thanks for coming twice. Enjoy people coming back to watch the trial continuously. I think you're right. What you're hearing is what they've got. The strongest bit of evidence would probably be the video from the recording studio where they go into the car, because without that, there's not really an argument as to who is sitting where, and then they attach then the trajectory of the bullets. But that's all they've got. I mean, I could go up there and say, all right, we had the cell phone video that was played, and when you see that these two cell phones were traveling together, and then all of a sudden they're separate, what's to say that Cortland didn't stop the car after Melly got out, went to the back seat like he was pretending to look for something, and then shot them from there? Because it'd be easy for them to be distracted for him looking for something in the back car than to sit in the front seat, turn around, and shoot. There's no evidence to say that he didn't do that. There's no evidence to say that he did. But it's reasonable. It could create a doubt. I think they're just going with little bits and pieces of our argument and trying to piece it together as best as they can. And as best as they can is probably the title of their trial at this point.
Afi, I'll send this next question to you. NNQ family from YouTube asks, him and friends were in the same gang. So what is she trying to prove? Why would he kill his friends that's in the same gang as him? This is the question from NNQ, Afi.
Thank you, NNQ. So I think that's what we all want to know, right? So the prosecution is saying that the drive-by was staged. So explain to me, if the drive-by was staged, what was the motive for staging the drive-by? What was the motive for killing these two gentlemen who they were in the maybe same gang, had the same affiliation, they were friends? What was the motive? When did you stage the drive-by? Why? At what point, when they left the studio, everybody seemed friendly, everybody seemed to have a good attitude. No hostility. So I don't really know where they're going with it, but they need to show me why. When was this staged? Had you been planning it? Did you plan it when you left the studio? I don't think that they've done the job yet, but I think it's coming, hopefully.
Well, let's keep in mind, too, we've heard from the father of YNW Juvie that apparently there had been something physical that happened in the days before this between Melly and Anthony Williams. Whether or not we will hear about that in testimony is a totally different thing. So I'm waiting to see if we hear anything about that type of thing as well. Let's see. At NixFan821 from Twitter, Terry Austin, what happens next if the jury convicts Melly for murder? And what does happen next if that happens?
Well, we will then have the sentencing phase where that jury is going to determine whether or not he will get the death penalty. And that's going to depend upon the aggravating factors that the prosecution has already listed. They think that it's, cruel and unusual. They think that it is premeditated. They think that it is gang related. Those are just some of the aggravating factors that the prosecution has said they think should apply here. And that jury is going to apply those aggravating factors. And don't forget, we've mentioned this before, it used to be in Florida that you had to have, and in most states, a unanimous decision as far as the death penalty is concerned. Governor DeSantis has written a new law just recently that you have a 8-4 instead of 12-0. And so with 8 members of that jury, they could say, yes, we would like to impose the death penalty. But we're still far from that. We have to see the rest of the prosecution's case, obviously the deliberation, then we'll have the decision of that jury. And of course, even if the jury does decide on the death penalty as far as Melly is concerned, there will be appeals. There's no doubt about that. And the process would take a very long time. So we have some ways to go before that.
Yeah, most certainly. And that law, Governor DeSantis just signed it in April. So this is very new. It came in response to the Parkland school shooter, getting life in prison rather than the death penalty, which many people believed he deserved. Our next question from TikTok comes from Sunglass Kid. And Brian, Sunglass Kid asks, why did Melly stay in jail when Bortland had gun residue on him?
Yeah, well, thank you, Sunglass Kid, for the question. I think it comes down to the allegations. So it's a number of reasons why someone has bond or bail. It's a number of reasons as to why it might be higher than your co-defendant. I think the major reason here is that the evidence, at least at the point in which bond or bail was being decided, appeared to be stronger towards Melly being the shooter, and therefore there being greater aggravating circumstances there than that of Henry, who is the driver, and merely, according to their theory, was a co-conspirator or helped after the fact. And so with those two distinctions, they would have asked for more bond or more bail or even remand, meaning that there's no amount of money that can get this person released, than as opposed to his co-defendant. And that's based on their participation in the crime, the evidence that they have, the likelihood of success based on the evidence, as well as the punishment, one facing the potential death penalty, the other facing life in prison. I think that's why one is still in jail and one was able to bond or bail out.
Afi, this next question is going to you. All-American Allison _ from Instagram asks, can they use Melly's song against him as a confession? I think she's referring to Murder on My Mind.
I think that was already brought up. And first of all, thank you, All-American. I think that was already brought up maybe pre-trial or maybe even after the trial started. And the prosecution is precluded from introducing that. And I believe it was released or it was created before the murders. So I don't believe that that's going to be introduced.
Yeah, most certainly. It was written while he was doing time on another case and released before the homicides. That is certainly true. Mm-hmm. All right. We are going to keep taking your questions. So keep them coming to us. YouTube, Instagram, Facebook, Twitter, and TikTok. We'll get to as many of them as we can, but we have to take a quick break. Stay with us. We'll be right back.
For the ones that just came in, we're going live on the main channel tonight at 10. Well, 9. We'll go at 9. Then recess. We just waiting for them to come back.
Latasha Gaffney from YouTube. She asks, so is the motive gang related?
Well, I think the prosecution is trying to say that the motive is gang related. That is the only motive that they have presented thus far. And without the witness who's currently on the stand, Danny Polo, who was an undercover agent, he is trying to establish that this was gang related, that it could have been, and we haven't heard all the testimony yet, but it could have been a motive for these killings, that perhaps he was trying to prove himself as far as this gang was concerned. He talked about national gangs. He talked about local gangs. And so I think that that is the only motive that we've seen thus far. We could see other motives, often crimes like this. It could be financial. And Jeanette, you actually interviewed Christopher Thomas's dad, who thought perhaps it could be something related to their brand and selling the brand and splitting the money, or perhaps it could be that there was an argument. So, right now, we haven't seen any of that evidence in trial. The only evidence we've seen so far as motive, as far as the prosecution is concerned, is this gang. Now, by the way, they don't have to prove motive, but it does make it much easier for that jury to understand why the prosecution thinks this crime occurred.
Most definitely. And Terry, there, as you said, there could be a couple of things going on here. Maybe it is a gang thing. Maybe there is money involved. I mean, who knows? We are waiting to see that. And, the prosecution, as you said, too, does not have to present a motive, but it sure helps when the jury's trying to wrap their heads around this stuff. Red drop, ! From YouTube. Brian Buckmeyer, what's the main reason why YNW Melly would get the death penalty, even though there are artists that have worse issues but don't get the death penalty?
I would have to know what artists we're talking about. Just kind of throwing a dart out there. I would guess either it depends on jurisdiction. If an artist committed a crime in New York, for example, we don't have the death penalty. It would depend on the aggravating circumstances. So the reason why they're looking for the death penalty here is because they're saying that YNW Melly's crime was so heinous or so callous, and also that there was a gang affiliation. And then kind of touch on that gang affiliation aspect as well. They have to prove it is to some extent, because not only as it helps in their trial in terms of answering the question of guilt or innocence, it's also going to help in terms of sentencing or the penalty phase when they ask for those aggravating charges to reach the death penalty. And I think the circumstances of what the prosecution has in their head as to what YNW Melly did is why they're saying this should be a death penalty case. The other artists that you're referring to, if they were murders, I think it would depend on the circumstances in those murders.
Definitely. All right, Big Dog 59 from YouTube. Afi, how important is it to put Demons in the car at the time of the shooting?
Thanks, Big Dog. I don't know that it's important to put him in the car at the time of the shooting. I think the focus isn't Portland. The focus is Melly. And we already know that, Devins. It's very important to put him in the car at the time of the shooting because we're trying to say that he is the person who pulled the trigger. And I think that's what the prosecution has been doing with the phone situation. And that's why yesterday's testimony was so important by the testimony made by the custodian of the records, because we are trying to say that Melly had this phone and he is the person who was in the car because we know the phone was in the car at the time of the shooting. So it's critical to put him there at the time of the shooting. Yeah, most certainly, because they're saying it occurred, that these shots were fired from the back seat. So it's critical. It doesn't get any more critical than that. Joriha from YouTube asks, isn't the witness's identity already compromised since he's being live streamed and viewers know his name and location? And this, of course, Terry, is about the undercover detective, Danny Polo.
Well, so far, we have not seen Danny Polo on the stand without his mask. And I will say it is a full face coverage other than the eyes. You can see the eyes. And I think the issue really is here that it is being live streamed. He does walk around. And when defense counsel asked their questions prior to the jury entering, defense counsel did say, look, you're walking around without a face mask. I saw you sitting outside without a face mask. What's the difference coming in here? The judge then said, it sounds as though you're concerned. You have this bounty. This is live streamed. More people would see him as far as his facial features are concerned without that mask. So I do think that at the end of the day, I don't know how the judge is going to resolve this issue. We had a juror who said she was uncomfortable with the mask. We might see a jury instruction that is more detailed, saying you should not feel uncomfortable. This is for his protection. You all are not at risk. I think right now the attorneys are trying to draft an instruction that will ease the uncomfortable, how uncomfortable this particular witness is at this point in time. So the mask is a big issue, and I think Danny Polo will be able to wear it, but it's a guess at this point. And if he is, it'll be a serious instruction.
I'm very interested, for one, to see how the judge rules on this issue. We're going to take a quick break, so keep those questions coming to us on YouTube, Instagram, Twitter, Facebook, and TikTok. We'll get to as many of them as we can in this hour. I'm Anjanette Levy, and you're watching Law and Crime. We'll be right back.
Y'all make sure y'all hit that like button. We're going to break this down tonight on my main channel on live.
Thanks for joining us. I'm Anjanette Levy, and we're taking your questions this hour in the double murder trial of YNW Melly. So we're going to get to as many of them as we can in the short time we have left. Brian, I'll send this one over to you right now. VSOP_VVS from Instagram. What has literally been the strongest evidence against him thus far? Because just to throw out there that the car surveillance shows him getting into the car, and as we all see, both cars pulled out in the same direction, one following after the other. We don't know what happened once the car got down the road. So that's weak evidence to me. So that's a long question and statement from VSOP, but VSOP wants to know what's the strongest piece of evidence.
I think you hit the nail on the head. Like your question is phenomenal in that it also has the answer. It is the strongest piece of evidence they have, but it in of itself is not strong. Because if you don't have this video, and this is the way I think about it, if you don't have this video of YNW Melly going into the very seat that the prosecution is accusing the bullets from coming from, then what do they have? It's the only piece of evidence that I can see so far that unravels the entire case. Now, if you don't have the trajectory of the bullets, that's one issue. If you don't have the bodies, that's another issue. But in terms of what they have and what would make the case crumble, in my eyes, almost completely, it would be the video of them getting in. Because if that's all you had, all you would have is maybe Henry being the only one that goes to the hospital and says, my two friends are dying, and Melly is not in the car or not there to report it. So maybe you can say, hey, we believe because of his absence, he must have been in the shooting, but that doesn't help. So to me, the strongest, even though it is pretty weak, is the video of him getting into that very seat that they say the shots came from.
Our next question, I'll take this one. It's from Catherine Vargas from Facebook. How long is the case supposed to last? Will there be any breaks for July 4th? Well, Catherine, the answer is they're off the week of July 4th. Obviously, there's a holiday in there, and then they don't go have court on Fridays. So that would be a very short week. So they're off that week. And we think that this case could wrap up by the end of July. So that's what they're forecasting right now. Our next question, Offie, is from Becky S. from YouTube. If YNW Melly is found not guilty, will it be easier to convict Bortland? And what charges is Bortland being charged with?
I think that it would be equally difficult to convict Bortland, but I do think the prosecution. I don't know if it's going to be the same prosecutor, but they will have learned a lot from this trial with Melly. They will know what their pitfalls are. They'll know how to be prepared with their evidence and with the information that they're trying to introduce into court. For example, Melly's girlfriend's mom and her testimony, they'll know how to treat that. You know, it's just, this will essentially be a test run for them with Bortland, excuse me.
It kind of is a test run for them with Portland. Our next question, Terry, Zach P. Productions from YouTube. In terms of the overall legal system, what type of ramifications changes might arise from this court case?
Well, I think the biggest ramification would be this death penalty issue, because if in fact the death penalty is something that the jury comes to the conclusion, I think that 8-4 new law that Governor DeSantis put into place will be something that not only the courts in Florida will be looking at, but an issue that could go back up to the Supreme Court. The Supreme Court has looked at this issue several times, and ultimately, Florida was able now to put it back to 8-4, but I do think that that's going to be challenged. So obviously it has other ramifications as to whether or not you can use music, whether or not, you can include certain evidence in the trial. But I think the biggest issue here is the fact that they are asking for the death penalty on a case where most people are saying, even if he's found guilty, why would this be a death penalty case? We saw with the Parkland shooter that case was a case that was a death penalty case. And even in that case, they did not elect to have him convicted and have him put to death. He obviously pled guilty, and the sentencing phase, the jury decided, look, we're not going to put him to death, even though all those aggravating factors existed. So I think the death penalty is probably the biggest issue in this case.
I think so too. And with that new law, it'll be interesting to see how that holds up when it's challenged. TikTok question for you, Brian Buckmeyer. Official 2023 Melly fan asks, why is he not allowed to talk to his family? And I think that Melly fan means inside the courtroom.
Yeah, it's an issue that a lot of us defense attorneys have with both the courts and their court staff, in the sense of they would argue is just the mechanics of it all doesn't work. They don't want to have anyone passing information, contraband, touching each other. There are very strict rules about what you can and cannot do in a courtroom. And oftentimes those rules are limiting the access that a defendant, especially when the person is incarcerated, may have with family. Now, are there exceptions? Of course. Have I had the opportunity to have a client say goodbye to a loved one, a child of theirs, or family members, whatever it is, before they're sentenced and go off to upstate? We call it upstate in New York because they literally go from one of the 5 boroughs to upstate New York for serious jail time. Yes. But during a trial, I don't know of any judge that will bend court rules to allow for any interaction. So that's why you'll see Melly kind of looking off to the side and voicing to family or friends, because there's not that ability to interact with them more personally.
Yeah, most courts have very strict rules about that, and they don't want this to be social hour. But it just depends on which court you're in, how strictly they enforce these rules. Anna _Aaron Trout from Instagram, Offie, is he going to take the stand at some time? What do you think?
Thanks, Anna. I doubt it very much. Defense attorneys usually do not. They do everything they can so that their client does not have to take the stand, because of course the client has the right not to testify. But also, I've said this thousands of times, defendants are under so much scrutiny. Anything they do is going to be picked apart from how they breathe, how they speak, whether they sound remorseful. If they sound remorseful, why? Whether they're talking or speaking assertively, whether they're speaking gently. Anything they do is going to be highly scrutinized, and depending on how you lean, you are going to interpret it positively or negatively. And it doesn't matter what they say. It's all about behavior, mannerisms, and what you expect a guilty man or an innocent person to say on the stand. So it's just troublesome. And not only that, when a defendant takes the stand, you don't know what you're going to get all of the time. They can open the door to admitting evidence or admitting a line of questioning that previously would not have been admitted. So you don't want to do that. There are also, prior bad acts that may be able to come into play that they may be questioned on. So it's just a minefield, and a lot of times it's just not worth it.
Yeah, certainly. And defendants open themselves up to a lot of cross-examination when they take the stand. Let's get to our next question, Terry. We have less than a minute, so it has to be quick. Kick It's Mackle from YouTube. Does the court know that the undercover detective is known for making false accusations? This seems like this person's making a statement here. We don't know anything about that.
Well, certainly the court may know, but I don't think anyone else in that courtroom knows. For instance, the jury or anyone in the audience that I'm aware of, that has not been introduced. They did the voir dire of the undercover agent, and none of that came up during that voir dire. The only issue that came up and the only issue that mattered to that judge was whether or not he was in fear of his life and whether he could wear that mask.
Yeah. Well, Terry, thanks so much for being with us. Thanks, everybody, for being with us as well. Brian, Offie, thank you. I'm signing off. And Michelle, you will be taking over. We'll be back right back. You're watching Law and Crime.
Okay, yeah, you right. But they saying that Sack Chaser was using the phone that Melly used. So him and Sack Chaser was sharing the phone.
His nickname, Sack Chaser. Right before you, you'll notice that all of those messages are coming from Sack Chaser. I'm not claiming that that means that all of those messages are from him. I am saying it's proof is positive that the phone was being used by him at times, or that would never have materialized in that way. And this notion.
So they saying both of them was sharing the same phone, so they can't even say that's Melly phone then. If him and Sack Chaser sharing the phone. Let's see what's going on with this.
Take your time. Wayfair, it's got everything.
The press conference at 3:00 Eastern time. Wherever you're watching from right now, whatever social media platform.
They found debris next to the Titanic, and they were saying, by them coming out saying that they found debris, is saying that basically what they found, the new debris that is new, it didn't come from the Titanic. So I don't know if they're trying to say it came from this submarine or what, but let's listen in until we wait till the Melly case start. But
app or website, wherever you're watching from, provided that it's coming from a genuine WFLA source and hasn't been repurposed by somebody else. I can tell you that on our WFLA platforms, we are going to have the press conference right here on this stream where you're watching at 3:00 Eastern time from Boston, Massachusetts. Jessica's comment has been on screen for some time. Let's get to it. And really, this is a potentially really smart question here, Mark. Hashtag KJB, is it possible the banging sounds was from the falling of debris? I mean,
and I apologize, just as JB did before, when you see me looking away, because my phone is blowing up from other people in the community who are either passing me information or asking me information.
Mark, if you need to step away for phone calls, texts.
No, we're doing it because I'm not the only one of us who is. I just saw one of the people I was just messaging with on a competing news network on my television. So we're all trying to keep each other in the loop, and we're all banging ideas off of each other. So back to the question. I just wanted to apologize. I'm not.
No, it's fine. I get it. You don't have to apologize. Believe me,
I'm trying to update. So actually, if I hear something,
so they found debris
give new
from the submarine,
Yep.
but they haven't found the submarine.
I think the question was, is it possible the banging was from the debris falling? I don't think so, because that banging was heard, more than 24 hours after the vehicle went down. It wouldn't have taken that long for the debris to fall.
Right.
So
if banging was heard Tuesday, remember to remind our audience, right. I'm helping Mark here. Tuesday into Wednesday morning was banging sounds were apparently heard.
Right. And I'm less and less optimistic that was live crew members in an attempt to signal, just because now we found debris. If the debris, in fact, is part of Titan, then there wouldn't. I don't think there would have been anybody alive, and we haven't had a significant sound event. We've had banging, but not a significant sound event since the vehicle went down. So that pretty much rules out an implosion after it striking the bottom.
Milta wants to know, hashtag KJB, is it possible that it was crushed under pressure?
Absolutely.
Yeah.
It's one of the main scenarios.
How small of a hull breach could cause the potential for the hull to completely give out? I mean, if it was the size of a toothpick and water coming in at that depth, again, approximately 1.5 miles to 2 miles down.
I'm not a naval engineer, right. But at a 1.5 miles down, I don't remember off the top of my head what the pressure is, but it's pretty good. Then you're, a quarter inch. You had a quarter-inch hole. The amount of water that would ingress into that vehicle, you wouldn't be able to stop it before you had too much.
Let's go back to the Melly case real quick. I'm back and forth, y'all. So, and we're gonna break all this down tonight on my main page.
offer some variation of that such that the answer to the juror's question can be met, which is why. That's why. And I think they need to know that the why does not concern any issue with respect to this particular defendant. The third is the problem that we had before, which is, as brought out during Mr. Alistein's questioning earlier, the state could have chosen any expert in gangs. They elected to choose one who has threats against his life that don't concern this case and is undercover. And therefore that they have precipitated this problem. I think Mr. Mr. Melly, I think our client has a right to a jury of his peers, one which has been selected and is seated, and his right to both confrontation and to a juror that has been seated supersedes all of the rights of the media, of the state to have an expert or a witness who could have been, and when they could have chosen any other expert. But our third proposition would be that we take a break and address this after lunch, after the jurors had an hour or so, and we then bring her in and see what her problem is. If it's not the mask, I'd be highly surprised, but maybe that's the first step. But we'd ask the court first to reconsider, and second, to reconsider letting him testify in this fashion, and second, to reconsider reading an instruction that gives the jury a little bit more than he's testifying in a mask. Let's continue.
If you have an instruction that's agreed to, I don't really have an issue with it. My issue was the way you drafted and crafted this instruction is that I'm telling the jury that I'm looking at the media's right to be here over his right to confront his accuser, and that's not the way the way it was crafted and worded to me was not the right way to handle it, and I wasn't going to do it.
Okay.
All right. So the second issue that you had is having the witness, and it was a testify without a mask. I don't have any issue with discussing that further with the witness. I did this because he told me he was in fear for his safety. And his family's safety, and this is what he does for a living. And I made my decision based on that because this is being a live stream. I don't know whether or not he would how he feels about it. And I guess that's subject to further discussion. As far as taking a break, I think that's the best way to handle it. We'll take a break, give the juror an opportunity to go have lunch. And once she comes back, the first order of business that we can do is to talk to that juror about how she feels and whether she's able to continue. If everybody's okay with that, that's the way we do it. Proceed, just see how she feels. If she's not suffering from anxiety anymore, if it's strictly an issue of the mask, then we'll know where that stands and we'll address it. And I can ask the witness then how he feels. So we'll take it one at a time.
So yeah, that was quite the hot topic before the lunch break in Florida, to mask or not to mask. And with that as the backdrop, I'm joined by Law and Crime Network's Brian Buckmeyer, as well as criminal defense attorney Natalie Whittingham Burrell. Natalie, I'm going to start with you here. What do you make of the defense's argument? Do you think the mask should have been allowed in the first place? I mean, this witness has testified in other cases in the same county with the same mask on.
I absolutely agree with the defense attorney. I don't think any witnesses should be allowed to testify with masks on, because one of the ways in which a jury is able to interpret the veracity of a witness's testimony is the manner in which the witness testifies. And that way you can see their facial expressions and kind of gauge whether or not you believe that they're telling the truth. By covering up someone's face, you're obfuscating or obscuring some of that. And so I don't think that that is the appropriate thing to do. And I think it violates Mr. Demmons' right to confront his accusers, to see that person testify on the stand. there were less intrusive means to be able to let that witness testify while protecting his identity from the media. They could have just turned the camera away from his face while the jury could see him. It prejudiced demons in so many ways. I don't know why that was allowed. And I don't care how many counties allow it and how many states. I don't think it's ever appropriate to let a witness completely obscure their faces.
Brian, what do you make of the jurors' note and their anxiety about the witness's mask?
I mean, it's fair. Jurors are people. They come in with their own baggage. And so you having a fear of what happened to you as a child and seeing someone being robbed makes sense. But I think there's a deeper question here is, let's say we try any one of the three options, right? We remove the cameras, let them speak only with the people there. Does him taking off the mask relieve her anxiety? When she goes to deliberate, is she still going to think of the guy as, oh, he's the guy with the mask who then took it off? Is that going to color her testimony? Is just taking the mask off going to just absolve all this altogether, even though we took this break? And if the answer is no, unfortunately, that means she's got to go. And I know that creates a whole other issue that we have only 3 alternates. They'll go down to 2. Maybe this trial extends a little longer. Someone gets sick. Kids need childcare, whatever it may be. And that's where it gets really scary, because if you drop below that 12, then you have a mistrial. But at this point, unless she tells me, yeah, once he takes off the mask, I'm good. All that anxiety is gone. I can wipe it from my mind. This whole experience is gone. In my mind, I'm thinking, I don't think you can stay.
Well, that's very interesting, Natalie. How big of a deal do you think this could be in everything that Brian just pointed out?
I think that it comes down to they have to voir dire this witness and see whether or not she is so prejudiced by watching this witness testify with a mask on. And if they voir dire the witness and the witness says, yes, take it off, I'm fine, and neither the defense or the prosecution thinks that the juror is lying, then sure. But if the juror expresses any hesitation in being able to be fair and impartial after watching this person testify in a mask, they're going to lose that juror more than likely, and they should lose that juror. You know, no judge wants a mistrial. They want the case to go through to its end, but you also do not want to prejudice the defendant. You want to make sure that they get a fair trial. And it's possible that that did not happen here because of the manner in which this witness testified.
Well, there definitely has been a lot of twists and turns in this case already. Another one popping up today with this mask issue. They're supposed to have it rectified after the lunch break. They are currently going to come back from lunch very soon. So hopefully we will see a resolution and see what happens next. We are going to take a quick break here on Law and Crime, but much more to cover here on this Melly trial when we come back.
Win a trip for 2 to Miami Beach, including air, hotel, VIP tickets, and $500 gift card for the 20.
I think they let that motherfucker wear that mask just to make the jury feel like he's a dangerous person, that Melly's a dangerous person. Just, I don't know, man. That was kind of crazy to me, because he's saying he got a $50,000 bounty on his head and all this shit. So I think they really did that just to paint a picture towards Melly, like he's in the gang and they're very dangerous. Because if you in fear for your life, like what's and then what's the point of him coming up there and talking about the gangs and shit? Like, I understand that y'all saying Melly in the gang, but as of right now, they have no evidence that the gang has anything to do with this case. So what was the point? I think that was just to paint a picture of Melly, make it seem like he in the gang and this undercover officer is terrified of his life and all this. I'll go back to the submarine real quick. So update on the submarine. They found debris from the submarine, but they haven't found the submarine. And they said in that pressure of the water, the submarine can be crushed. And y'all got to think about how the ocean flow is too. The ocean flow is just like a pool. So mind y'all, just say if you in 6 feet, and then y'all know how it sloped down when you go in 12 feet. That's the same way how the ocean is, the ocean flow. So just imagine if they wandered off a little farther, it go deeper.
A landing frame and a rear cover from the sub after receiving a WhatsApp message live on Sky News. So this is breaking. So a friend of two of the men missing on board is receiving information. Please let me repeat. I am attributing this to Sky News. We have not independently confirmed this. This is information that is coming from what I am seeing right now, a singular source, and it is a source that is international for us here in the United States. It is Sky News in the UK. So a WhatsApp message to a reporter with Sky News from a friend of two of the men says that within the debris field, and Mark, I'm sure you're checking your phone to see if you're hearing the same thing in your circles, but that
I just got a message from someone who knows two people on the ship, and who is a longtime, very close friend of mine, and an explorer as well, a member of the Explorers Club. Just texted tail end and then the landing platform, the Explorers Club WhatsApp chat message. So apparently that was on the Explorers Club WhatsApp chat message. I work in the UK and Ireland predominantly, and have for many years. I am quite familiar with Sky, and they are a very reputable news source.
Yep.
Yeah, I would.
So is it safe to say the ship is falling apart? The submarine
level as
fell apart?
NBC or CNN or
and please
ABC,
let me be clear.
CBS.
Let me be clear. My comments are not doubting the validity of the report.
No,
I'm just
no.
expressing. All I'm doing is expressing my unfamiliarity with. Look.
Right. Frankly, I'm surprised that somebody leaked that to Sky, because I would have thought that we would have kept that kind of in the circle. But it might be somebody that knows somebody in the circle that got that message and decided. I don't know, but I can tell you that the source I have reported on the Explorers Club WhatsApp chat message, which they are privy to, that it was a tail end and then the landing platform.
And really quickly, let me just finish that thought. What I was trying to articulate is that I cannot vouch for an international news organization. I can only say that a news organization internationally is reporting this, and this is now starting to make the rounds on social media. It's not necessarily, for example, we have affiliations with the Associated Press. We have an affiliation with NBC. We have an affiliation with News Nation. These are sources that we are in direct contact with all the time. AP, NBC, News Nation are three of our most common affiliated organizations, Sky News being an international organization. I cannot speak to the validity of this report because I don't know anybody at Sky News, but it is breaking on the internet and it is making the rounds on social media. And Mark is seeing this in that same circle as you've been calling it, referring to it, Mark. So what does that tell us? One more time, do you want to read it? They're calling it a landing frame and a rear cover.
Not a real cover, the tail end, which if you look at, if you get a side view of that up, there you go. So basically what they're talking about is this back end. You see how it, comes up into a type of a cone. That would have been a piece that would have been readily identifiable. There would still be some hope if it was just the landing frame, because that would have been one of those external components that I discussed that might have come off the craft, but the hull could have remained intact. But if there's a piece of that tail end near it, then that's not looking good.
Mark Martin, JB Buno here with you live. Really, Mark has dedicated a lot of his time to joining us here on stream. Mark, can I ask you a question really quickly?
Sure.
You have any interest in hopping back on stream with us after your 2:00 appearance? Because after the press conference is done, I'm just saying, me being just a curious person, I would be very interested in to hear what you have to say in the aftermath of what we learn at the 3:00 presser.
Yes, I will tell you that I got to be on standby at 10 minutes till 2 for the other.
So if they found the tail end of the motherfucking submarine, hey man, it's over with. It's over with. The ship has fell apart. Back to the Melly. And if y'all not following me on Instagram, make sure you go follow me on Instagram, Music 101 CEO. Let's see, did they start the Melly case? Okay, they started. Like I said, we're going to be breaking all this down live on my main channel tonight at 9.
At or about the time of the murder, including conversations with the defendant's mother. So, for example, I'll show Your Honor now what has been extracted from that same cell phone. And this is also information that predates the murder. So there's no reason or motive to lie or anything at that point, because at this point the victims are still alive. And so we also then have the defendant's conversations before and after, which show the same pattern of speech, the same way he is communicating on these, which show that he is the individual that had care, custody, and control of that phone at the time. So I'm going to start, and I appreciate the result on this one. And this is from a phone number that is identified as...
Your Honor, before we continue, I would respectfully suggest that we take my retort to their argument piecemeal so that we don't lose the significance of each.
She's going to, counselor's going to proceed with her argument and her thing, and you'll get a chance to speak.
So we have, this is prior to the homicide, this is going to be August 30th of 2018. The phone number 772-501-6942 that's said to a crazy lady. Again, we'll get into why it's a B shortly with the next witness. In this case, this is the defendant's mother. This is Jamie King. Because if you go to state 63 on the subscriber records, that is the other phone number that is subscribed to Miss Jamie King at that time. Additionally, defense counsel provided Jamie King's records to the state to show that that is her phone number and represented it as such. So this is discussions and where he is calling her mom about and talking about the argument and the fight between the defendant, Sack, Chaser, and as he's referred to at this bottom message, where she is talking to Mr. Demons about that person, showing that it is not Sack that is on the other end of this line or this particular phone call. Moving on, and then we also have where a discussion, this is still August 30th, and talking about how, I don't know what all going on. He's talking, making a live video talking about your mother. It's going to make people hate you. That's why I have never and would never do that. I love you. And that's your best friend. This is not for social media. And
Sorry,
then,
hold on a second.
sure,
Can you repeat that, please?
Of course. Sure. So if you go through this whole conversation here, starting with, how is his sister going on social media talking about punching me in face, my fault, from the individual that's been identified as Jamie King by the phone records, by the subscriber records that are in evidence already. Then going on to reply is, you started it by texting his mama, it's gonna be problems, and not even knowing what you're talking about. You a grown-ass lady doing childish shit. Ain't nobody tell you to text her. She minding her business, going to work, you effing with her. The response then, she could have called me or texted me back, not have you or daughter all on social media talking about fighting me like I cussed at her. I didn't even say one cuss word when I texted her. I said nothing disrespectful and you know it. I wish you took up for me like that when Aunt cussed me out and tried to fight me. Again, this is talking about Anthony Williams on that. So like I said before, the next message on August 30th, I don't know what's all going on. He's talking about making a live video, talking about your mother. It's going to make people hate you. That's why I have never and would never do that, because I love you and that's your best friend. This is not for social media. So continuing on, next page. In this particular page, this is again referring to these social media conversations on that with regards to Anthony Williams and the defendant's mother. So for here, no, I'm not your actions I take up for you. I have people telling me your son doesn't care about you. That Jamel Demon's mother is Jamie King. Here she is identifying that she is speaking to her son in that. So then I want to go then to after the time of the homicide, in which Jamie King is sending a text message to her son, send me your location. I'm in Stewart. I love you so much. He then sends a return the location showing at or about the time of the crime as to who was using and doing that. Okay, love you again from Jamie King. I'm at your gate. I'm going to get the trash. The next response is bring Mariah, which you honors already heard testimony that Felicia Holmes, her daughter, Mariah Hamilton, was in a dating relationship with this defendant, and that at this time, and that there was conversations, and that she has identified Mariah as Mariah Hamilton. Then there is okay. It continues. He then asks his mother to buy him a Glock ASAP, and telling her, like, go now. So she then responds, okay, what's wrong? She says, I got your 45s. Then his response, I just don't want no illegal gun. Well, that's not illegal. Continuing on, but I'd rather have a Glock 40 or a 19. She says, okay. His response is, I'll pay you when you get down here. She then says, okay. Then,
Your Honor, I object to this. Is she going to read the entire phone? This does not go to the heart of our objection. This is being done for the cameras.
Counsel, I asked her to put on a proffer of what she anticipated, is what she's telling me and how it's relevant. Go ahead.
Continuing on, there's been discussions about other witnesses. I'm waiting on track to cash at me the $1,000. And then she asks, is someone threatening you? To which he replies, no, ma. This is his mother that he's talking to. And he's saying, I'm not scared, just listen. This is clear proof and evidence that this is Jamel Dimmon's phone because he is speaking with his mother on that one. So on the last one that showed November 3rd, 2018, love you too, Ma, and yes, son, on that, where she is identifying that as the phone that is being used by her son, and that is on the subscriber records. However, that's not the only thing. In addition, the defendant also, in other conversations at or about the time of the homicide, sends a photo of his driver's license to someone to be able to authenticate and show specific items in terms of going through and setting up a rental. And even has so much as puts the address of 805 Northeast 4th Avenue.
What's the date of that, Counsel?
That one is September 28th of 2018. That shows that the defendant has previously been to the studio and knows that. Also talks, and this is a conversation with Adrian Davis, in which he is using this phone, sending in pictures of his driver's license from this phone. And some of the other pictures and items that Your Honor has in front of you, there's pictures of credit cards, front and back, with the defendant's name on them. There are multiple things that show that this phone was being used by the defendant, Jamel Dimmons. There is no evidence before Your Honor that it was being used at the time of the crime by anyone else. In addition, the defendant is seen on camera in possession of a phone as he is leaving the studio on October 26th of 2018. At that point, there's a phone in his hand. That phone then tracks, and you can follow on all of the call detail records and all of the mapping that was done put in yesterday to show that this phone goes from the studio and is consistent with the phone of Anthony Williams, which is the other phone that's on there on T-Mobile, and all the way out to the scene of the crime. Then it continues until at which point the phone separates, and Anthony Williams' phone and Christopher Thomas's phone goes to the hospital, and that is what is consistent with that, and they are recovered at that location.
And Counsel, I don't understand this Celebrite, why that would put a different name on the text messages.
So in terms of that, if there is any time that anybody else has used the phone, and for whatever purpose on that, if they have logged in on a other social media account, that could put that name on there. However, it is who was using the phone at the time that is important. And so this and all of the information, everything on these, show that it was the defendant. And by the defense suggesting it was not, that makes even more items relevant to show. For example, defense counsel brought up and showed images of a very intimate nature that were shown of the defendant. The contention that someone would allow photos of his penis to be accessed and sent out by friends and other people is absolutely ridiculous. So just the conversations that you have read as well include pictures of the defendant, and those are in there with other people in which he is acknowledging interaction with them and the contents of the photos. Those individuals are the ones who are identified as the gang members that he is associated with.
Thank you. Anything else?
Now, defense. Yes, sir. Thank you. What we have said, which is the gravamen of our objection, is that this phone was used by others as well. First question the court put to the state was, how come it says Sack Chaser Howard? I was told that was the nickname of one of the deceased. The state's answer is, I don't know. And that answer is not good enough. The court circled back to that question and asked, and the state just said, I don't know, if you, on Celebrite, it might capture it like that with T-Mobile, and it could capture it like that if anybody else ever uses the phone, ever. That, first of all, she's not an expert. We have not heard testimony to that effect. And if she's offering testimony as to how a phone can get identified by a certain moniker that is not the defendant's, and her answer is, I think that that's how it might be if somebody used it ever, would run in direct contravention of this notion that he used the phone exclusively. So the state is conceding by its very contention that somebody else used that phone. They're just saying, I don't know when, and I don't know how the name got there. If what the state says is true, that if somebody uses it once, it will thereafter identify the phone in that person's name forever, we would need an expert to say that, not Miss Bradley, somebody who actually has knowledge about it. It would also be curious that if several other social media accounts and what have you are being accessed by Mr. Demons, how come the multitude of times that he has accessed these accounts did not cause the phone to affix his name to that phone? Again, our contention is not that the phone was never used by Mr. Demons, it's that it was not exclusively used by Mr. Demons. So the state wants to show that Mr. Demons used it, and they put up a screenshot of a FaceTime call showing Mr. Demons up in the top corner. That particular call, the state, by that photo, has established the foundation for that photo. The state then makes mention of Jamie King and saying that the phone number that is being communicated with in a certain message is the other phone number that was on that account. The state conceded before the break that there were several phone numbers on that account. So it's not just one, there were several. However, if for some reason this court were to find some self-authentication by reference to a person as mom, maybe that phone authentication for that particular, and I think actually the state conceded it, not on purpose, but when discussing a message, she said that's proof that that particular message or phone call was between Mr. Demons and his mother. That is how evidence works. Now, because she has proved that there are certain photos, and if the court notes, I mean, I have photos on my phone. Everybody here, I'm sure, has photos on their phone. It's not all of them. And some of the photos that were displayed for the court are clearly not selfies. So somebody else took the picture. Did somebody else take the picture because he was a celebrity? Did somebody else take the picture because he was a friend? Did somebody else take the picture because it was one of the people that he associates with, that he's friends with, that takes a picture of him because they're hanging out? That does not establish that it's his phone. That doesn't even begin to establish. As a matter of fact, it puts the phone in somebody else's hand at the very moment that picture is being taken. So the question becomes, what is admissible? The state, if what is clear, is that for all the gang stuff that the state is now trying to seek to admit, all of this identifying information that she can point to for all these other conversations, she cannot point to for the ones that she's trying to put in that this hearing is about. So she's asking the court to extrapolate. I can prove that he had this phone in his possession sometimes, maybe a lot. I can't explain why it has somebody else's name on it. Could be any reason. And I'm going to offer my expert opinion as to why it has Sack Chaser Howard on there that I can't back up by any expert I've ever spoken to. And previously I just told you I don't know how it got there. Conceding that it's not in his name, that it's clearly been used by others, which she said is why Sack Chaser Howard was there, but she figures, I guess it got Sack Chaser Howard there the single time that somebody else used it, and every other time it was Mr. Demons. That's not logical. It doesn't make sense, and even if it did, the state does not have the evidence to establish that. The conversations that are at issue here are all these gang conversations that the state seeks to put in. If I'm not saying that they can't authenticate and lay a proper foundation for any of those exchanges, if they can, they should do so in accordance with the rules of evidence. But they can't say, ignore the rules of evidence as to everything I want to put in because I'm going to show that he spoke to his mother on this phone and spoke to his girlfriend on this phone and spoke to his younger brother on the phone at some other time. That's why each conversation is independent. Each exchange is independent because each exchange is an item of evidence that requires a foundation for its admissibility. So what we're doing is inviting error when we say, okay, we can prove some things. We can't prove the stuff that we're trying to admit, but we want you to extrapolate and infer that since this phone was in Mr. Demons' hand at some point, at a lot of points, then we get to put in everything and call it his conversations. And the state said Mr. Demons was seen leaving the studio with a phone in his hand, and that phone was tracked. How do we know that that's the phone that was tracked? How do we know that that was the phone in his hand? We do not. That is an inference they're making. It's an argument they're making, and they're entitled to make an argument if they can lay the foundation for the evidence upon which such an argument would rest. But just saying it doesn't make it so. There is nothing that identifies the phone that's seen in his hand as he walks out of that studio as the one they tracked anywhere. And, Your Honor, the problem with doing this wholesale, if this witness is going to testify to a particular exchange, lay the foundation for that exchange like every other trial that we have ever been in, instead of saying we can just obviate the need for that because the foundation is going to be laid outside the presence of the jury by hearsay from the prosecutor without a witness. And so the actual particular conversations at issue here are the gang conversations, or the purported gang conversations that the state wishes to admit through this witness. If this witness can establish them, or if the state can bring another witness in here to establish each one of those conversations as being out of the mouth of Mr. Demons or out of his fingers in a text, then they're admissible. Otherwise, they are not. And they're hearsay.
So in addition, Your Honor, I'd point out that the cell phone records that have been introduced from T-Mobile include the IMEI phone number and the MSDN, which is the identifying phone number for that phone. All of that information, again, correlates with the other information that's already been put in there, showing that this phone was, in fact, Mr. Demons, including, not limited to, what this defense has also been provided, which are all of the Apple records, which show that the defendant, on October 29th of 2018, then took and bought the phone with which has been introduced into evidence, the extraction of that, and brought over all the data from the prior phone he was using on the night of the incident, which is the one that was tracked. And that is able to be seen through all of the data, and that is clear from the records from T-Mobile as well as from Apple. And those are items that are admissible as business records and are not hearsay, as we previously discussed. And that's what I have up on the screen now, so Your Honor can see the fact that the iPhone, and specifically, when I scroll over, goes back to Jamel Simmons, YNW Melly Booking at gmail.com, and goes forward and gives an address in Vero Beach, Florida, which is consistent with what is on his numerous driver's license transcripts, which have been put into evidence. And there it goes through and shows all of the phone numbers and everything else for the defendant.
Let me just add this briefly. There is evidence that Mr. Simmons lived in the same house as several other people. Identifying an address means nothing. The state, I think, mentioned that in its opening. Several people lived in that house. An address means nothing. Secondly, if I want to set a motion on this court's calendar and they show that I called chambers, it doesn't mean I spoke to the judge. I spoke to your courtroom deputy, maybe, or secretary. Artists get bookings by their manager, the person from whom this phone was obtained. Saying that it says YNW Melly Booking is proof, or at least a suggestion, that it was used by somebody who books on behalf of the artist. Artists don't get on the phone and make these arrangements themselves. That's why they have managers. If there was a transcript of a proceeding that took place in this courtroom 7 months ago, and it didn't say who was speaking, coming in here and saying that here's a transcript that shows Mr. Howard was speaking on June the 21st, so therefore he must have been the person speaking several months ago, would be preposterous. This example is tantamount to that. And so the thing is, again, I am not contending that there are no exchanges that can come in. I am saying with the gatekeeping function of this court, it is incumbent upon the court and the state to make sure that the foundation is laid for each exchange that is being adduced. We cannot, none of this, I just mentioned, they have none of the exchanges that they're seeking to put in, they can type in. Why don't they start with those? They're telling you about stuff that happened months before, months after, not the ones that they're trying to put in. Those are the ones that need to be authenticated, and each conversation needs authentication because it identifies a speaker. And therefore, when the speaker is the defendant, it circumvents any hearsay objection because it is non-hearsay by definition because it's a statement of the defendant. And also in terms of establishing the foundation so that the jury knows that when you show me this and tell me and get up there in closing and said, he said this, we know he said it. And it can't be because we have a FaceTime of him and his little brother months before. Each individual conversation needs to be, the foundation needs to be laid for each individual conversation. It cannot be dumped in wholesale. And if they can establish the foundation, it comes in. If they can't, it stays out. But if we just sidestep the whole procedure by saying we're going to let it in because we're saying this is his phone when we have several indications that the phone was being used by others before, after, and during the entire period at issue in this case.
A couple things, Council. Number one is I don't have any evidence before me that the phone is being used by other people at any time. I haven't heard that evidence at all. What I do know is that, and what the state's indicating to me and what she just proffered are pictures on the cell phone which appear to be the defendant, as well as conversations which appear to be between the defendant and his mother, which is extrinsic evidence of circumstances surrounding the use of the phone and the pictures on it. And it seems to me that that's sufficient to show what the state is claiming, that this is his phone. I don't understand, and I still don't understand how young Chaser Howard is on that. And to be candid, I don't have adequate explanation, but some of the texts that are between the two phones, the 9807 and his mother's phone, is clear to me that is a discussion between he and his mother, and that he's using the phone. Also, the state provided a certificate 6 weeks or so beforehand from the pawn shop that showed that Mr. Demmons was using the phone, identified this as his phone. I have that, as well as the subscriber information showed that the mother listed on the account, and there's multiple phones on the account. In any event, we're going to proceed and see where it goes, but it seems to me that there is extrinsic evidence, circumstantial evidence that this is Mr. Demmons' phone. What about the juror? I want to bring a juror in. I want to talk to her just to find out as to whether or not she's okay to proceed, and just find out a little bit about that. All right, so we're going to do that now. Can I have those 2 messages? Anything this week?
While we bring her out, can I just say this? Yesterday I presented, and for some reason the internet access is not booting up. It will shortly, I'm sure. I presented the court with evidence that that phone was being used while Mr. Demmons was in custody. So the court said there's no evidence that it was being used by others. That's evidence. The fact that it has Stack Tracer, however, I understand, but you said you didn't, and just let you know that I did present you with that exact information that you say does not exist.
Bring the jury. The reason I brought you in is I had 2 messages during the last witness's testimony, and the first one said, I don't feel comfortable. Why does he get to see us, but we can't see him? That's your message to me?
Yes.
And the second was, I need a moment. I can't listen properly. When I was a child, I seen someone get robbed and am having an anxiety attack.
Yes.
And I guess my concern is, are you able to sit as a juror, or you think this is too much for you? I'm trying to figure out, and that's why we took a little extended lunch break to figure out whether you feel comfortable and you're up to it.
Yes, I feel comfortable, but I just don't think it was appropriate for someone to be masked up like that. And plus you guys didn't even tell us, like you don't know what people have been through, so it's just like, it's shocked me, like I shocked. So yeah, but I do feel like I can handle it. But that just wasn't appropriate.
I'm sorry?
I said I don't believe that was appropriate.
Well, some things I make certain decisions about things, and then we go forward with it, and I instruct jurors. And are you think you'd be able to follow those instructions, and you pay attention to the evidence, or do you think that you're concerned about the masking that is going to affect your ability to follow the instructions and follow the evidence?
Yes, I can listen and follow the evidence now that I know he's gonna have one mask.
And the anxiety issue, we're past that, you're okay?
Yeah, I took my medication.
Thank you. With the order reflect the juror stepped out, counsel remained along with the defendant. Counsel, she indicated she's still curious as to why the witness is wearing a mask, but she said she's able to follow the instructions, and she's able to listen to the evidence, and she feels comfortable going forward. Anything you want to?
Yes, sir. We believe we again move for the court to employ the procedure clearing the courtroom and allowing this witness to testify in a manner that will allow the jury to assess his credibility as it would any other witness. We also believe that in lieu of that the instruction that we offered, which answers her curiosity, should be given. The court indicated that it declined to give the defense instruction because of the component of the proposed instruction that referenced the court balancing and prioritizing the media's right to be here over the defendant's right to confrontation. We do think that that is an appropriate part of the instruction, but short of that, the rest of the instruction, which excises that portion, we believe to be called for, especially in light of this witness's persistent curiosity. We answer all their other questions, and this is a pertinent, because this is one that goes to the heart of why she is being denied the opportunity to make the observations pertinent to his credibility.
Thank you. What's the state?
But I think we can come up to an agreement. I think we just need to more closely track the instruction, and going off memory that it's 3.9, so I'm pulling that up now as to exactly what witnesses are supposed to be judged on. And I think the problem is the way defense has it is you observe their demeanor and facial expressions, and the actual text of the jury instruction doesn't say that. The actual text of the jury instruction reads as follows. You should consider how the witnesses acted as well as what they said. There's nothing about demeanor or facial expressions in any way, shape, or form in that jury instruction. So I think if it read that the court has ruled the next witness to be permitted to testify with his face concealed with the exception of his eyes, the court has made this ruling because this witness has expressed that there have been threats made against his life by people unrelated to this case. Your jury instructions advise you to, and then to edit it to comply with the standard, to consider how the witnesses acted as well as what they said.
One moment to defer, Your Honor.
So Ms. Smith had a good point that it would not be appropriate for Your Honor to explain the logic behind your ruling or to say that it's because of this, but if you wanted to instruct them that the witness has said that there have been threats made against his life by people unrelated to this case, that would be fine.
Thank you. So my thought is, as far as the instruction was prepared by defense counsel, the first page reads, the court has ruled that the next witness, I'm just going to say Mr. Detective Polo, Danny Polo, will be permitted to testify with his face concealed with the exception of his eyes. The court has made this ruling because this witness has expressed that there have been threats made against his life by people unrelated to this case. And we're going to leave it there, and I'll tell them that further instruction on how you judge credibility of witnesses will be given at a later time. All right, so let's bring the jury in. Let's get the witness back up.
The witness is in the BSO office down the hall, so I'm going to go to my new grab them so they aren't anywhere. Can you approach grab any items, Jordan?
Without having a hearing, having them bring their lawyers down here and everything else, it's a whole, it's a major move.
Understood, Your Honor. We believe the stakes of this matter are as high as they get.
Jury entry. Thank you. Please be seated. Let the record reflect the presence of the defendant, his counsel, the assistant state attorneys, and one of our jurors, we need to get the witness. So, ladies and gentlemen, in your absence, I was asked again to instruct you regarding the witness Danny Tolo and the fact that he's wearing a mask. I have ruled that Danny Tolo would be permitted to testify with his face concealed, with the exception of his eyes. The court has made this ruling and this decision because the witness has expressed that there have been threats made against his life by people unrelated to this case. The court's going to instruct you at a later time as to how you judge credibility of witnesses, but that is why he was permitted to conceal his face except for his eyes. All right, can we get back to Mr. Tolo, please?
One of the case sidebar.
Please have a seat. Please have a seat.
Thanks, sir.
You are Detective Tolo, correct?
Yes, sir.
Detective, you were previously placed under oath to remain under oath. Detective Tolo, you understand?
Yes.
Thank you. Counsel, you may proceed.
Yes, Your Honor, this is ended. I was offering if they wanted to their daughter the witness in any area of his expertise.
Yes, sir.
Go ahead.
Thank you. Good afternoon, sir.
How you doing, sir?
You've seen my case before.
Yes, sir.
It was on February 17, 2022. You recall?
Objection, Your Honor. This one non-responsive.
Sustained.
What was the objection?
I sustain the objection. Ask your next question.
Did I take your debt?
Yes, sir.
What date did I take your debt?
I don't remember the exact answer.
If I show you a copy of the transcript, would it refresh your recollection?
Yes, sir.
Okay.
You have all four? Mr. Hall?
I'm referring to this.
Okay, which one is that? So I should know it. If Council is okay, just show me.
The date I mentioned, February 17th, 2022.
I don't have a copy.
Does that refresh your recollection?
Yes, sir. Thank you.
And on that date, you were asked, I'm not sure if I did the question, whether or not you had ever been declared an expert in any proceeding.
Correct.
And had you?
At that time, I don't believe so.
Okay, so your expertise, or at least there's no court that had acknowledged your expertise up until February 17th of 2022.
That I can recall.
Okay. Are you contending that you were an expert before that?
Has the court declared me an expert? Is that what you're asking?
Well, we know you didn't. You said no.
Right.
Okay.
Can you clarify the question?
Okay, let's strike that. I think we. You were asked about your training and education just now by Ms. Bradley.
Yes, sir.
And you said 500 hours of specialized training.
Yes.
In the area of gangs, organized crime, and money laundering. It's all the same.
It interconnects when you're working in gang case.
Okay. Of that 500 hours, how much was money laundering?
I'd have to go through all my certificates and subtract a couple hours here and there. The bulk of it is gang investigations and organized crime investigations, which are one and the same, basically.
Okay. So you're not saying that money laundering is one and the same as gang training? You're
No,
saying
sir.
It's not?
I'm not saying this.
Okay, but that's included in your 500 hours, right?
Yeah, a couple hours out of that are money laundering, specific money laundering. Maybe if you want me to take a guess.
I don't want you to guess anything.
Okay, then
Okay. But you can't tell us, as you said.
I can give you an estimate.
And can you tell us how much of your training was actually gang related?
The majority of it, bulk of it.
How much? Time-wise?
The exact hours, over 400 hours.
Over 400?
Yes, sir.
Okay. So 400 was gang. And you have certifications that indicate that?
Yes.
Did you bring them with you?
No, sir.
Okay. And you were telling us that you also have a certification from an association of some sort. What's the name of that association?
The Florida Gang Investigators Association.
Is that a law enforcement exclusive organization?
I think, do you mean, do people other than law enforcement go to those trainings?
No, I mean, can someone other than a law enforcement officer get certified as a Florida gang by the Florida Gang Investigation Association?
Yes, sir.
You know if that happened?
Yeah, prosecutors, other attorneys that go to the conferences, victim advocates, they all go to these trainings.
I'm asking if they can get certified.
Yes, sir.
And you're saying prosecutors can?
Yes.
And police officers can?
Yes.
You're saying defense attorneys can?
I don't see why not. I'm not sure if they would bar a defense attorney from the training. I haven't seen that in their website.
Okay, but you can't tell us that?
No, I can't, sir.
And when you said other attorneys, then you mean civil attorneys?
Yeah, attorneys like the attorneys that represent the victims in certain crimes. I'm not sure what they fall under.
Okay, and you're representing that civil attorneys that represent victims in crimes can get certified by the Florida Gang Investigation Association?
They can take the trainings, yes, sir. And then the trainings result in getting your certificates.
Okay. And how many hours do you need of training to get certified by the Florida Gang Investigation Association?
The exact hours, I'm not sure of, sir. They put on basic courses and they put on intermediate courses, they put on advanced courses. You take them, you get certificates for those, and then they put specialized courses on specific gangs. You do all those as well. So exactly the amount of hours, I don't know exactly the amount of hours, sir.
How many hours did you go train or get instructed with the Florida Gang Investigation Association before you got certified?
Close to 100 hours, maybe more. It's an estimate.
Okay. So it could be less than 100, you're saying?
It's around 100.
Okay. And the other, you said there was a certification that you have from some academy of some sort?
It's called the National Gang Academy. It's a 8-week-long gang specialist course that's put on by a company called the National Gang Academy, a training company.
And the National Gang Academy Training Company?
It's called the National Gang Academy. It's a training company. They provide training.
Okay, and the National Gang Academy Training Company, who are the people who give instructions? What is theirs?
The person that runs the academy, I'd have to look at his bio. I don't remember exactly what his experience was, but usually the people that run these organizations have 20, 30 plus years teaching in gangs. I know the Florida Gang Investigators Association, their president is one of the lead gang detectives in the state of Florida.
Okay, but where I was asking about the academy, you don't know the credentials of the people who give instructions and credential you?
I don't recall, sir. I don't recall the exact credentials of this person.
Okay. And were they gang members?
No.
Okay. So it was some other people who professed to have expertise then conferring certification upon you.
They're putting you through a course. You have to pass tests. You have to, it's not just multiple choice tests. There's written exams. There's videos. There's interactive portions of the class where you have to call the instructor and discuss what you've been doing in your game training. So it's an 8-week interactive course.
Okay, eight weeks, you said?
8 weeks, sir.
Okay. And you said that some of the knowledge that you gleaned in order to deem yourself an expert is from gang members that were in custody trying to work off their time?
Some of the interviews are gang members in custody. Some are gang members not in custody.
Okay. Let's start with the gang members that are in custody trying to work off their time.
Not all of them are trying to work off their time.
Okay. Well, the gang members that are in custody.
Yes, sir.
Okay. Some of them are trying to work off their time?
Some.
Okay, let's start with that. Have you ever experienced a situation where you're talking with a gang member or any defendant that's trying to work off his or her time and they're being deceptive with you in order to achieve some ulterior motive, like taking off their time?
If they're being deceptive, I don't want to talk to them.
Well, I know you don't want to,
yeah. But
you judge whether they're being deceptive or not based upon stuff like their facial expression.
When I interview people, I will give them baseline questions that I already have the answers to, things that I might already know about them, intimate details about their lives or people they associate with, other gang members, things about their specific gang. And if they're being deceptive in those questions that I already have the answers to, then my interview is basically over. Or I call them out on the fact that they're lying to me, and then see if they want to change to being honest. And then at that point, maybe we can reestablish a connection. But if they're lying right from the get-go, if I ask them a question about their affiliation or about someone they associated with who's a gang member, and they're lying, I usually don't want to keep talking to them because it doesn't benefit me to be working with someone that's going to lie to me.
I understand. But essentially what you're saying is your assessment of their credibility governs whether or not you pursue the interview, right?
Yeah, if I find that they are not lying to me, then I continue my interview, and then I continue to assess whether they're lying or not.
Right. And if they're lying to you and you think they're not, you're not saying that your assessment of somebody's credibility is bulletproof. You're not saying that.
No.
Okay. Right. Now, the ones who are reformed gang members, are they themselves in danger when they just give out knowledge willy-nilly about their past lives?
I mean, based on the rules and bylaws and stuff like that they have written down on some of these major national gangs, you would think that it would be frowned upon. But like I stated, everyone wants to put everything on social media right now. And these founders of these organizations are giving all these intimate details about stuff they've already been convicted of, they've done time for, because they're probably trying to get views on YouTube, views on Instagram, they're trying to make money, and it's an incentive for them to tell true stories. So they're being interviewed by others in the same gang world, because it's usually, most of these interviews are, they'll put a couple guys that kind of came up at the same time that were founders of the organizations, co-founders, and they'll go back and forth.
Will you agree? I'm sorry, you're done?
Sure, sir.
Will you agree with me it's an incentive? Getting clicks on YouTube and making money that way is an incentive for them to tell stories. It's not necessarily an incentive for them to tell the truth. Because
sure,
nobody would. Okay. And some of your expertise you gained from watching YouTube videos?
No, sir. That just gives me a little insight into their world and into the gang mentality. It's rare when someone, a typical person doesn't brag about committing violence upon someone else on YouTube and how they had to crack someone's head open or shed blood so they can make it in this gang, right? That's not typical of a person to want to admit. It's incriminating against themselves, and why would anyone do that?
I understand. My question to you was, some of the body of knowledge that you obtain in order to hone and advance your expertise is from YouTube. Is that true or is it not?
Some of the knowledge came from interviews, yeah. Interviews that I watched with people that I found to be telling true stories because it's been corroborated based off written documents.
So that's a yes.
Sure.
Okay. And you were asked about your hands-on investigations, and I think your answer was suspects or special investigations. You remember that?
Correct.
And you said over 30 suspects you have engaged in investigations since 2022. You never gave us a number of your involvement in special investigations themselves. What's that?
The number 30 was reference to just, I believe, the amount of blood gang members we've investigated this past year. The reason I separate investigations from suspects is because a lot of these investigations, if it's an investigation into a criminal organization, that's one investigation might involve 20 subjects. So it would be misleading for me to say I only did one investigation when it was really 20 separate investigations that are all linked together into one organization, charged as an organization.
Understood. Now, my question to you, however, was how many special investigations have you engaged in yourself?
Give me a second to think about it.
Please.
Thank you, sir. This is probably an accurate representation. I might be missing one or two. A couple.
What are you looking at?
Uh, 18 gangs and about 30 different investigations.
So you 13 or 30?
30.
30.
Yes, sir.
So when you gave us the number of 30 suspects.
That was blood investigations.
Okay, that was blood only.
Yes, sir.
Okay. All right.
In the last year.
So this Florida Gang Investigation Association, can anybody get certification if they don't attend the criminal justice only part of the training?
I don't work for FGIA, sir. So I don't know what their rules are for that. I know I'm allowed to take the classes. I know I've seen prosecutors take those classes with me, because I've had prosecutors come to the trainings with me. So I can't answer on behalf of FGIA.
Okay.
I apologize.
Okay. So you were thinking that non-law enforcement can get certified, but the only people that you've seen in there with you are prosecutors and other law enforcement.
Yeah, they're not law enforcement. You mean cops or just people involved in the legal system?
People involved on your side of the legal system.
Okay, that's
Overruled.
Yeah, that's different than law enforcement.
Okay. So when you're saying it wasn't only law enforcement and you're talking about attorneys who represent people, victims of crimes.
No, we've had victim advocates at the trainings before.
Or at the trainings giving instruction?
No, taking courses.
Okay. So it's not limited to certified law enforcement or retired law enforcement or probation, parole, corrections, juvenile justice, intelligence personnel, prosecuting attorneys, judges and crime analysts and intelligence analysts, evidence technicians for a law enforcement agency, or any other person deemed appropriate for membership.
Look, you're reading that from their website. That's perfect. I mean, like I said, I don't work for FGIA, so I don't know where their cutoff is.
Okay.
And I don't have access to their website at the moment.
So in fact, it may be just a law enforcement only organization for certification purposes.
I can't answer that question. I don't know.
Okay.
I believe I've met people there taking courses that are not law enforcement. So I'm speaking from personal experience. I'm not saying whether they're allowed to or not. I just know they've been there.
Okay. And you were saying some of the, do you work undercover?
Yes, sir.
Okay, you were saying some of the undercover members, you know, of undercover law enforcement officers who are members of gangs.
In an undercover capacity.
Yeah. In an undercover. Are you?
I am not, sir.
You did. So you would agree that those undercover officers who went that step would probably know more about the intimacies than you would.
I was the case agent on that.
Okay. And
case agent being the person that leads the investigation and tells the undercover what to do and what evidence I need to gather, what evidence is beneficial to prove the gang, and I collect all the evidence, meaning knowledge, instructions from other gang members. So I direct the investigation, they're the undercovers.
Okay.
So when I'm the undercover, someone tells me what to do because it's their investigation.
okay, but in an undercover capacity, you never went to the step of getting inside a gang so you could be in the room where intimate gang activity was actually being discussed among gang members only.
It's recorded. I'm in the room.
Okay, so you're just in the room with them, but you are not a gang member, so they wouldn't be discussing stuff that only gang members discuss if you're not one.
So what I'm trying to explain is that undercover operations are recorded audio video. So the fact that I wasn't present doesn't mean I didn't see it.
Okay. So the gang Bibles that you spoke of, are those the same gang Bibles that you can download on the internet?
There's some incomplete ones on the internet. I haven't really found any great ones on the internet. But there are some that have been leaked. Some of the information is pretty accurate. Some of them are outdated. It's not the most recent ones. Like in this case, there was an updated one that was revamped in 2016 from the original 1996 version.
And you were saying to us, I think, that the rules of a gang in one location or locality don't necessarily translate into being the rules of a gang in another part of the country or part of the state, right?
Yeah, so basically, like any organization, the farther you get down in the structure of that organization, things are lost in translation. So the head of the snake can only control the tail so much.
So you're saying that the only reason that there are different rules in different parts of the country of a gang is because they're lost in communication, or do different localities have different rules?
Both.
Okay, both. And you're saying that part of the information that you gather is by just walking up to somebody that you see and see if they'll talk to you and tell you all their intimate gang stuff?
I've done that before, yes.
And even when they don't speak to you, you said you look at the way they dress and the way they stand?
Sometimes.
What about the way they stand?
So specific to, let's say, the Bloods, they align, some of their symbology is specific to the right side. So they might stand and cross their arms a certain way with the right arm over the left arm. Or they might wear their hat to the right. They might put a bandana on the right, or put a different colored bandana on the left to show disrespect. So those are little nuances that if you know you're talking to someone who is a member of that gang, it could mean something.
Okay.
If I just meet you and you happen to be wearing a red bandana in your right pocket, I know you're not a member of the Blood, sir. So I would not think this guy's a Blood.
I understand that.
You get what I'm saying?
But what I'm saying is, how are you learning? You might be learning whether the person you're speaking to fits the criteria of the gangs that you already have formed. You're not advancing your knowledge about gangs by looking at them and saying and identifying things that you already think apply, right? You understand the distinction I'm making?
No, please rephrase that.
Okay.
Interesting question.
by the way, before I get to that question, you're saying that for example, Bloods are favor their right, so they might cross their arm right over left, right? When you say might, are you saying that sometimes they cross it left over right?
Yeah. Okay. I'm just saying.
So that's not really a rule, then, right?
Nothing's written in stone, sir.
Okay.
So that means Bloods typically wear red, right? That's one of their primary colors. They also wear green, which is on the East Coast a blood color. And new recruits within the Bloods are told to wear brown or tan with a white T-shirt. So there's different things. You can't just stick to one aspect and be like, oh man, that guy didn't cross out that B that one time, because you're supposed to cross out your B's or your C's, sorry. So just because you didn't do it one time doesn't eliminate what you are.
I understand. I'm just trying to get your testimony straight.
Sure.
You were saying sometimes they might wear their hat to the right.
Correct.
Meaning sometimes they might wear it to the left, and sometimes they might wear it straight, and sometimes they might wear it in the back. Right?
Yes.
So that's another rule that sometimes they do.
These aren't rules. These are a rule is something that has to be followed. These are just things that they're known to do.
Okay.
Like wearing the color red. They don't always wear the color red. If they did, it'd be very easy to just find all your Bloods, or at least start looking for them.
And all of the 6 times that you testified as an expert were they in 2022 and 2023, or just in 2023?
I testified in federal court a couple months ago on the Zone Mafia family case as an expert. I testified last year sometime, I forgot when, on a 9 Trey Gangster Bloods case, attempt homicide case. And I testified in a couple of sentencing hearings between that time and now.
Okay. So whatever the case, would it be fair to say your expertise is just kind of in its embryonic stage, since you weren't certified as an expert as of February of last year? You agree with that?
I think my knowledge of the topic has grown over time. Obviously, that's why I do recurring training. But
and you said that you've attended every conference since 2016, right?
Yes, sir.
And your first conference, what conference was that in 2016?
The Florida Gang Investigators Association.
And how many times? I'm sorry.
The conference.
Okay. And you said every conference since then? Is it biannual, annual, every month? Annual?
Annual, and then they host additional trainings throughout the year. You wouldn't call them conferences. They don't call them conferences. They're just trainings, 2-day trainings, 3-day trainings on specific things, like outlaw motorcycle gangs, I believe was the last one I took.
Okay.
I think a 2-day training.
And you got your certification in 2016 then?
I have to look at my certificate. I think it took, I had taken 2 years before I got the advanced certificate.
Okay. All right, one last thing. You said that you have taught, like, I'm not sure I got that right, but was it like at-risk youth kind of seminars to just say no kind of thing?
I've spoken to the youth both while I was working on the road, before I was in the Strategic Investigations Division, trying to help the youth not join gangs or leave the gangs that they're already in, trying to give them an opportunity. That's something that I do on my off time as well, not for the sheriff's office. I volunteer, and I've taught at a victim advocacy conference for the Office of the Attorney General. And youth outreach is important to me.
Okay, and thank you for that. We need that. My question to you, however, is when you are speaking and would you actually call it teaching, or is it speed?
It's teaching. They have questions. You're teaching them how to properly document gangs, because if it's done incorrectly, then you're gonna ruin the system. And it happens. We see it where.
I thought you were talking to kids. Are you talking to young youth? You're teaching.
Oh, I thought you were talking in general when I'm teaching.
Okay.
I'm sorry, sir. No, kids. Yeah, no. When you talk to the youth, you're talking about. It's a prevention thing. It's more of like, don't ruin your life, and explain the risk factors and what not to do, and try to help them understand that there's a life outside of that, because some of these kids come from families and neighborhoods, socioeconomic areas where they don't see the light, so they need to understand that there is a way out.
I agree with you. What I'm asking you is, when you do that, you are doing nothing that any other of these fine officers could do, or I could do.
I think I could relate with them a little better, because I understand the gang mentality, because I've interviewed so many gang members, so I understand where they're coming from.
Okay, but you have included references to motivational and just stay on the straight path speeches to you as among your teaching experience and your expertise?
Something I do, yeah. And you learn from those kids as well. You don't think you learn from kids that are involved in gangs?
Okay, thank you. One more. I have nothing further.
So Detective Pollitt, when you're talking about determining whether or not someone is or is not a gang member, do you go both ways?
I try to convince myself that they're not. I'm trying to avoid confirmation bias. So if someone tells me this guy's a blood, or is all off your family, or GD or Crip or whatever, I'll start looking for things to tell me that they're not. Because the second I can convince myself that this person's not a gang member, it's probably true that they're not, and that maybe it's just not enough evidence to prove they are. But when I'm going in there looking for evidence against it, and all I can find is evidence to support it, that's when it shifts, and I'm like, okay, this guy has to be a member. And this happens frequently because, like I said, sometimes people document gang members incorrectly, because they'll see a tattoo that they think means something, and they'll document that person as a member of XYZ gang, and then I personally know that person is a member of this Bloods gang. So then I have to go and figure out why someone believed this person was a member of this other gang, and then convince myself that that person was wrong and I'm right, or maybe notice that there might be two gang affiliations, like a prison gang and street gang, or a national-based gang and local street gang that they associate with. So multiple alliances.
Okay, so you mentioned that there can be multiple alliances. Can you give a definition of what it would mean to be behind the wall?
Behind the wall means in prison.
So are there different gangs that are behind the wall versus outside?
Yeah, there's different gangs in prison, and there's some of those gangs exist on the outside as well. So the United Blood Nation was founded as a prison gang to protect Black Americans against Hispanics in New York and Rikers Island. Little by little, that expanded and it spread to the streets, and then these multiple blood sets that were created in Rikers Island were now on the streets, spreading their ideology.
You used a term that we haven't defined. Ladies and gentlemen of the jury, what is a set?
A set, like a group, a different branch of an organization.
So you mentioned some of the organizational system. Is there a recognized organizational system in place for example, the UVN?
Yes.
And so can you describe a little bit about how that is organized?
So the United Blood Nation was founded by a handful of leaders within Rikers Island. They created the first 3 original sets, 9 Trey Gangster Bloods, 1 Trey Gangster Bloods, and G-Shine or Gangster Killer Bloods. Sometimes they go by different names. And there was, I think, a total of like 12, 13 different sets that were created. Each one of those sets, or each one of those gangs that fall under the United Blood Nation have a leader who they call the Godfather Head. Right, so that would be the top person in the organization, the Godfather Head of the GFH. From there, you have Godfathers underneath, and there's a couple more of those, and then they spread into different branches. And they have from there, from the Godfather, you have the highs, and you have the lows. That's the title of the rank. And sometimes they'll give those titles, the high and the low, they'll give it a separate title. So they might give it an associated title, like it could be anything. Like whatever set could call it whatever they want for their group. You have the highs and lows, then you have the 5th floor. 5th floor is your rank. You call it 5th floor or 5-star, or you're a 5-star general. Then the 4th floor, 3rd floor, 2nd floor, 1st floor, and you have foot soldiers. And that doesn't mean there's one person per position. There could be hundreds of people in one position. And then a little bit less in the next one, a little bit less in the next one, until you get all the way to the top. Like most organizations, there's only one CEO, there's only one big boss, and then there's assistant managers and associate managers and supervisors, floor supervisors. It's the same thing. You can only run an organization a certain amount of one way.
So in terms of your experience in training and dealing with gangs, is there a financial component to those?
A huge financial component.
Could you describe a little bit more about that?
Other than protection inside the prison system, once they spread out into the streets, one of the main focuses of the gang is to financially support the gang. And to financially support the gang, you have to make money. To make money, you have to sometimes commit crimes. It could be, and they don't have a rule on how to get this money, right? You can, some of the Bibles say, get it how you live, right? So pick a trade, make money. If it's rapping, it's rapping. If it's selling drugs, it's selling drugs. If it's selling guns, it's selling guns. If it's killing, it's killing. If it's doing home invasions, it's doing home invasions. And then that money in most gangs that report back to a prison system, they pay dues. Not all gangs do, but a lot of them do. They pay dues. These dues are collected at the very bottom. They transfer it over to the person in charge of collecting the money. The person in charge of collecting the money usually has a title. They might have a rank. They also have a title of treasurer. That person is then responsible for holding the money for the gang, so that if someone has legal troubles, they can pay for the attorney fees, or if someone needs, or if the organization inside the wall in prison needs food, commissary, shoes, anything, they can support their brothers behind the wall until they get out. That money is also used to get people back on their feet when they get out of prison. So that's the financial component. That's the money laundering component of the organizations.
So you talked a little bit about wiretaps and monitoring of specific phrases, spellings, things like that. How do you learn the phraseology or specific slang used by any individual set or gang?
Sometimes I'm not gonna lie, sometimes it's difficult. There's certain slang and symbols that we have yet to decipher, right? Because even if you have the dictionary, it might not even make sense because the slang the answer or the definition of the slang term or the code word is another code word. And unless you knew what the previous Bible said, you never figure it out. But for the most part, you get this based off of context.
Okay. Can you describe, you mentioned something about dropping a C or crossing out all the C's. How does that show up in the messages?
It's written in most, if we're speaking about bloods only, in the blood Bibles, it'll say you'll cross out all your C's and replace them with X's, B's, K's. Basically, just replace all the C's. And the reason that you replace the C's is because historically, when the Bloods were created on the West Coast, California, they were created to defend themselves against the Crips. The Crips were an organized gang at the time in the early 70s. They were decimating the local neighborhood street gangs, and the local neighborhood street gangs banded together and said, let's unify and become one organization. Malpairu was one of the original sets. 5'9" Brim, one of the original sets. And all these neighborhood street gangs, like I stated, there's neighborhood street gangs, eventually sometimes evolve into large national gangs. That's how the Bloods were created. So these neighborhood street gangs banded together, created the Bloods, started calling themselves Bloods, and began to multiply. And the main thing was defending themselves against the Crips. So most of their language is anti-Crip language. That doesn't mean right now there's a war between Crips and Bloods, but they might still disrespect each other. If they get into an argument, they'll use derogatory language that they've created to diss each other, make fun of each other, and to show disrespect, either graffiti or messages on message boards. They'll cross out C's, or Crips will cross out B's. They'll call each other certain words like Crips. Bloods call Crips crabs. That's their derogatory term. Crips call Bloods slobs. That's their derogatory term for Bloods. Well, these are little things that they do, and it's not, like I said before, it doesn't mean every single time they write a message they're going to do it, but it happens pretty frequently.
So in terms of the term FYE, fire.
Yeah.
What would that be translated to?
A gun.
What about a stick or a pole?
A rifle or a shotgun, a long gun. It's like a stick.
What about the term on the plate?
On the plate or being greenlit that means the gang has sanctioned your murder, basically. If you've been put on the plate, if you've been greenlit, or you've been labeled food, that means it's an on-site attack that needs to be done on you. And if you're a member of this gang and you know that Johnny Smith is on the plate and you run into him and you don't act accordingly, then you might also be put on that plate. You might also be labeled food, and you might be next in line, or you are next in line to be killed.
You also mentioned the term false flagging. Could you define that for the jury?
Just means claiming something that you're not. So saying you're a Blood and you're not a Blood, and saying you're a Crip and you're not a Crip, or claiming multiple gangs that you're not a part of.
So how, on that side note, how do these small neighborhood local sets of young kids, how do they wind up becoming actually real sanctioned sets with the Bloods?
To become sanctioned, so there's a lot of neighborhood street gangs that identify as Bloods. They'll call themselves Bloods. They identify as Bloods in terms of they've adopted all the signs, symbols, ideologies, clothing, all these things that the Bloods buy from. And they might have bits and pieces of knowledge that they've gotten from, friends or whoever, or the internet. And they try to follow this stuff. At some point, if you get a big enough neighborhood street gang that's claiming Blood, they will probably get approached by a national set. And it could be any one of the national blood sets will approach these neighborhood street gangs and tell them, see, it's almost like a cease and desist order. You either fold and you come tap in with the bloods and become official bloods or sanctioned bloods, right? Fall under one of the national branches, or your entire gang is going to be put on the plate. Your entire gang is going to be wiped out.
And if you could explain is the term real right?
So real right is in reference to a sanctioned blood, a blood that's tapping in, a blood that's associated to one of the national branches, that's doing all the right things as blood. So if you're saying you're real right, that means you're a member of the bloods, like the sanctioned bloods, not a neighborhood street set. And
I think you've already described or defined lineup, but if you could just make sure that's clear, please.
Your lineup in a gang is your chain of chain of command. So who's your foot soldiers, then your first floor, second floor, third floor, all the way up to the top. That's your lineup. So if you're a member of say a specific G-Shine Gangster Killer blood set, and they ask, and you're getting checked by another blood because they don't believe you're a blood, and they say, what's your lineup? You're going to tell them who you report to. And you would know, okay, my big homie, the person that brought me in to the gang, is so-and-so. His big homie is so-and-so. And the Godfather is so-and-so. And as long as you have the right answer, if the person quizzing you is a real blood, he's going to know that you're not lying. And that's how you catch you alive. If you're faking it, you're not going to be able to answer those questions correctly. You're not going to know who the big homie is. You're not going to know who the boss is. You're not going to know anything because it's not publicly advertised for the world.
And so in terms of if someone asks, who do you walk with, what would be the appropriate answer?
With the bloods?
Yes.
State your set and who your homies, who your big homies are. Basically, you'd have to identify who you report to.
When you say the term tapping in, I think you've used that a couple times. Could you define that?
Tapping in is what all of the unsanctioned blood sets are told to do. If you want to become a real blood, and by real blood, I don't mean unsanctioned sets are not real bloods. A gang is a gang. It doesn't matter what you call yourselves. Just because you're sanctioned doesn't mean you're not a gang. So if you're claiming to be a blood and you want to be a sanctioned blood, the first thing they tell you to do is you need to tap in, which is you need to start reaching out to people that are real right, people that are real bloods, sanctioned bloods, and start learning the knowledge, start gaining the knowledge, start getting these documents and learning the way to operate under the national guidelines.
You've mentioned knowledge. Is there another term that's used interchangeably with that word?
Englewood.
Like the city in California?
Exactly.
Okay. You taught, one of the other things you said, could you define what is set tripping?
Set tripping is something that's created by G-Shine. G-Shine and Gangster Killer Bloods. I might go back and forth. I'll probably just keep correcting it, not correcting but mentioning it. But Gangster Killer Bloods created that term basically. And set tripping refers to a little history. So when the Gangster Killer Bloods were formed, they were formed as almost like an enforcement branch to straighten out all the bloods that weren't acting accordingly, following the rules. And you have to remember they were in prison. So the rules are a lot more strict in prison because there's nowhere to go. You break the rules here in South Florida, you can move to somewhere else and they might not find you. In prison, there's nowhere to go. You're in a cell block with 50 other bloods. You start breaking rules, everyone knows. So set tripping is not acting accordingly. So that means if there happens to be a fight on the courtyard where someone needs to get slashed or someone needs to get beat and you didn't do what you were supposed to as a member of this gang, you're set tripping. And then now G-Shine, or GKB, Gangster Killer Bloods, they will come and they will enforce upon you the violence that you should have enforced on someone else. So there's little controversy with G-Shine because a lot of blood sets don't like them because they're enforcers. It's like, you know, like a lot of people don't like the cops because we write people tickets. The police of the G-Shine, of the blood world, right? They're enforcing the rules. And
So, Detective Fuller, are you saying that they commit violence upon each other?
Yeah.
And what do you have to support that?
There's, as I mentioned earlier, there's plenty of videos online of people that either false repping or not even people false repping. There's just videos of bloods that make mistakes and claim they are from one part of town when they burn it. And that was enough of a violation for them to get recorded live and live streaming getting beat for what they did. Everything doesn't rise to be put on a plate, everything doesn't rise to be killed, but you might have to take a violation.
So with regards to determining whether someone is or is not a gang member under Florida statutes, are there criteria that you have to look for?
Yeah, so the Florida statute that governs, that defines what a gang is and what gang members and gang associates are is 874.03. And there's different subsections. First subsection defines what a gang is, which is there's a group, whether formal or informal, of 3 or more people who have common identifiers, hand signs, colors, things in common, right? And as part of their primary activities, they commit crime. That's what makes them a gang, not the fact that they wear the same colors. And then after that, there's criteria that defines how you can determine if someone is a member or an associate. And these are, some of the criteria are adopts a style of dress, admits to gang membership, identified as a gang member by a parent or guardian, identified as a gang member by a confidential informant that's been proven to be trustworthy and reliable, identified as a gang member by a informant that hasn't been proven trustworthy and reliable, being associated with a gang member 1 or more times, associating with gang members 4 or more times.
Okay, so maybe grab you for, yeah, A through K. Does that sound familiar? Okay. With regards to the involvement, does every gang member have to be involved in every single criminal activity?
No, but like I said, they say get it how you live. So as long as you're bringing money in for the gang, then you're going to be in their good graces. So if your hustle is rapping and you're making money rapping, they're going to support you. They're going to bring you up and make sure that you're making more money and that you're doing what you're supposed to, and that you're supporting, in return, you're supporting the gang. And then you don't forget, you're not an individual, you're part of a collective.
So you mentioned kind of ranks. How do you get a promotion from one rank to the next?
Putting in work, so either completing what they call missions or just contributing to the gang, showing your loyalty. Someone above you would have to decide that you're worthy of moving up. A lot of the early steps are as foot soldiers. If you're a foot soldier and your job is to go do home invasion robberies, if you're out there doing a whole lot of home invasion robberies and bringing a lot of profits back to the gang, or a lot of guns back to the gang, or a lot of drugs back to the gang, then you might get a promotion. If your job is rapping and you're doing good and you're making money and you're bringing in money to the gang, you're taking the gang to shows and you're supporting them, you're supporting the gang, not supporting yourself, supporting the collective, then you can start getting promotions.
Okay. Is every aim and goal of a criminal gang something related to crime?
No, a lot of these gangs, like I said, were initially racially formed for racial reasons, to defend, for the African Americans to defend themselves against Hispanics, or Hispanics to defend themselves against African Americans or white supremacists. So initially it started off as something racial to help bring up their own people, right? So the Hispanics created gangs to bring up the Hispanic culture. The African Americans did to bring up Black culture and to help them get out of these areas and to support their neighborhoods and bring money back to their neighborhoods and make sure that there's success amongst not just the gang, but their culture. And that's the same for basically every gang, whether it's white supremacists, Hispanic gangs, Asian gangs, Black gangs. It's just, that's what gang culture is.
Is there things about prioritizing education for gang members?
Yeah, it's written into their bylaws. They don't want dummies, right? They want smart guys. If you're out there committing reckless acts and bringing bad attention to your gang, no one's going to want you. You might be out there committing robberies and doing stuff. That's your job. But if you're doing it recklessly because you're not a smart guy, they're going to probably tighten up on you and start telling you, you need to do this a different way. We need to teach you the right way to do this. Or you might just be a skilled rapper. You might be very good at sports, or you might be just a very smart person and you just do really well in school. So they want you to succeed in school so that you can maybe become an attorney or something that can help them out.
So with regards to G-Shine in particular, were you able to document 3 or more members of that criminal enterprise?
Yes.
Approximately how many were you able to document?
In reference to this case?
In reference to this case.
I think I stopped at like 17 or 18.
Specifically in this case, can you talk about how you became involved in this investigation?
I was asked to analyze the case and determine whether there was a gang nexus to it, whether Mr. Demmons was a member of this gang, and if he was, to look into it further.
So in terms of the things that you were trying to look at under the statute, in terms of subsection A, admitting to criminal gang membership, were you able to show that and document with regards to this defendant?
Yeah, so admitting to gang membership is not just admitting it to a police officer. If you admit to gang membership on a video, it's the same thing. You've admitted to being a member of that gang. So yeah, there's multiple videos of Mr. Demmons claiming G-Shine or GKB as a gang that he belongs to.
What about adopting the style or dress of a criminal gang?
Yes, Mr. Demmons was observed multiple times, more times than I can count, wearing the colors red, colors green, and like I stated, the foot soldiers are told to wear tan or brown. And Mr. Demmons, there's a bunch of pictures of him wearing this tan trench coat that falls in line with the time where he would have been a foot soldier.
And so we'll come back to some of those pictures in a moment. So what about adopting the use of a hand signs that's identified as used by a criminal gang?
Yes, Mr. Demmons knows all the gang signs, and he does them very well. He can do them very quickly, a lot faster than I can.
Can you explain what stacking is?
Stacking is a form of communication with gangs, within gangs. If you meet another blood, you might you might ask them who they roll with and say, oh, I'm a blood. And they might just stack his set, so it'll say where he's from, right? So it'll claim, they'll throw maybe a B for blood or a B for blood, and then follow up with every set has their own specific hand signs that they might throw up. So there's universal hand signs for the UVM and United Blood Nation. Those are just standard signs that all bloods kind of are supposed to know. And then every set will have their own hand signs. And then apart from that, if you're part of a set that is part of a certain neighborhood, you might also add your neighborhood stack into it. So if you live on 27th Street or something like that, 27th Ave, you might throw in your street, especially if you're in an area that's populated by a lot of different blood sets. That way they know where you're from.
What about in terms of associating with one or more known criminal gang members?
Yeah, so the way I was able to identify these other G-Shine members or the blood members was through contacts that he had on his phone and photographs that he had on his phone, social media, stuff that was publicly posted, stuff that was posted or that was privately inside his phone, not shared.
In terms of what about if they've been observed in the company of one or more known criminal gang members 4 or more times? Were you able to document that in this case?
Yes, there's hundreds of pictures of him with other bloods.
What about if they are identified as a criminal gang member by physical evidence?
Physical evidence would be the videos of Mr. Demons throwing up hand signs, the videos of Mr. Demons saying the G-Shine oath, their motto, all the social media posts, references he makes in songs about being a blood. That's all physical evidence.
Okay, so I want to
The
go.
Bible.
So we'll get to that in just a moment. So Detective Polo, are you taking into consideration that this could be a character or an act that's put on for social media?
No, I don't believe this is an act or a character. This is, as I stated, G-Shine is one of the more violent blood sets. They're the ones that are enforcing when other people are false repping, and that's what they're known for. So if a famous person were to false rep G-Shine, they would quickly get checked. That happened to those two kids. I don't know how old they are. Those two guys that were claiming sex money murder, the Island Boys. Fun haircut.
Okay.
Yeah, they were claiming to be members of Sex Money Murder, which is a set of bloods, and they quickly got checked by almost every blood that can find them on social media. They got branded, and they then had to recant and apologize.
Did you find any evidence whatsoever of any recanting or apologizing by Mr. Demons in the records that you reviewed?
There's no recanting, there's no apologizing, there's no one calling out Mr. Demons for being a fake blood. There's all I could find is support for Mr. Demons for being blood by other bloods.
Okay, in terms of the specific communications that you went through, were those on a cellular phone and email extraction? Or
Yes. Yes, it was on both.
Okay, I'm gonna start. I'm gonna make sure defense has a chance to see what's in the estate. Triple U for identification purposes only. Detective Polo, showing it's been labeled estate triple U for identification purposes only. Do you recognize those documents?
Yes.
How do you recognize those documents?
It's the email chain forwarded to YNW Melly booking at gmail.com from one Jaquan Burton. Same subject that was identified through his cell phone on his text messages.
Objection, Your Honor, to the reference of his cell phone.
From side by side. you know, I'm going to take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in the presence. Just leave your notes pads on your chair. Thank you. Don't discuss the case. No recess. Mr. Dennis, you need a rest break? Will you wait for a rest break, Mr. Dennis?
Okay, so there's the testimony from the detective. He is testifying with a mask, and of course, we're not showing his face there due to concerns with his area expertise. He is an expert in gangs and gang activity, and he is testifying there in court. Let's bring in my two great guests who are going to break this down with me now. I have Gene Rossi. He is a trial attorney, former federal prosecutor. I also have Aikisha Al-Shabazz. She is a former prosecutor with the New York County DA's office, criminal defense attorney, and professor. Aikisha, I want to start with you. I'm a former prosecutor too. I was with the Brooklyn DA's office across the East River there from where you used to be. And I had the experience of having a gang expert testify. And similarly, he testified under the cloak of anonymity in order to maintain his undercover status and also his area of expertise. What do we see here in court now? Is it a valid concern for this witness to want to be anonymous in this trial, or at least testify without his face being shown?
Absolutely. If he is, and I'm sure they did what we do here in New York called a Hinton hearing, where the prosecution would put forth some sort of evidence to demonstrate that if he was not being able to testify in disguise or anonymously, then his life would be in danger. And so he's probably still engaged in undercover work, which is why it's necessary for us to protect his life. This is very common, so long as the judge has explained to the jury that they should draw no negative inference, right? It's to make it look like this witness is afraid of the defendant or something to that effect, then it shouldn't be a problem.
Right. And Gene, the process of what we're seeing right now, the line of questioning, is this to establish this witness as an expert? And in your experience, what are some of the things that you're looking to draw out from a witness that you're ultimately going to offer as an expert in court?
Well, if I'm the prosecutor, I have to lay a foundation that says that this expert knows what the heck they're talking about. So you want to get the training, experience, years in office, conferences, but also how many times they've been certified by a state or federal court as an expert. That's the best foundation and the only foundation you should have for this type of expert.
Sure. And Aikisha, I want to get the perspective from the defense side. Gene was talking about what you want to bring out from this witness as a prosecutor. What are you sort of aiming to do when you're looking to voir dire or question a proposed expert witness being offered by the other side?
Well, exactly what was just said, and I think that this defense attorney did a great job at that. And I don't know if you caught when he said, "So you're sort of at the embryonic stage." He was like, "You're a baby investigator. You don't really do this. You're not a real teacher. You just go out and do lectures. You talk to kids about not joining gangs. You're not a professor or anything to that nature." So he's really just trying to undermine his expertise, quote unquote. And I think he did a good job there. Like, you just got here. You don't really know anything. I like that as a defense attorney.
Great analysis. We're going to take a quick break here at Law and Crime, but you stay tuned. We're going to come back. More of the YNW Melly trial coming out of Florida and more chatting with my great guests who will help me break it down. Stay tuned.